ट्यूशन पेंडिंग नहीं होगी।
फिर क्या क्या डिस्टर्ब कर रहे हैं वो? और 1 अप्रैल में हम कैसे डिसाइड करेंगे कौन किसको क्या
लॉर्डशिप
डिस्टर्ब
केवल
कर रहा है?
आइए में होगी, कोई भी डेट फिक्स कर दिया जाए, आइए केवल लिस्ट कर दिया जाए। दिस इज माय पर्सनल रिक्वेस्ट। आइए में भी लिस्टेड एंड एनी ऑर्डर में भी पास
आई विल फिक्स इट ऑन दैट डे ओनली। हम कुछ भी इसको
हुजूर केवल आइए को हुजूर लिस्ट कर दिया। नेक्स्ट
आई विल रिजेक्ट दिस आइडिया। यू वांट दैट रिजेक्शन?
ठीक है हुजूर, लेकिन आइए
देखिए 2 तारीख को हो जाएगा आपका मैटर। अब हो सकता है कि आपके क्लाइंट के किस्मत में कोई और कोर्ट हो तो अच्छी बात है।
नहीं, इसीलिए हुजूर उनके प्रेजेंस में जो भी हो जाएगा नेक्स्ट वीक में हुजूर केवल आइए लिस्ट कर।
हाँ, लेकिन हम प्रीपोन नहीं करेंगे, बोल दीजिए।
दिस इज माय रिक्वेस्ट लॉर्डशिप।
हम प्रीपोन नहीं करेंगे,
अदरवाइज हम मेंशन नहीं करते हो।
ठीक है, कोई बात नहीं। तो ऐसा फर्स्ट अपील कब का है बताइए?
फर्स्ट अपील 24 का है।
तो 24 का फर्स्ट अपील अभी लाइन में लग गया है।
हाँ, लाइन में लग गया है फाइनल।
नहीं, लाइन में लग गया है क्योंकि हम ऑर्डर किए होंगे।
जी, इसीलिए
इसीलिए ना
जी।
तो ठीक है। देखिए कोई भी चीज जब ऑर्डर करते हैं
तो
हम माइंड में रहता है कि इसको
कभी ये नहीं करेंगे, लेकिन पर्सनल ग्राउंड में हुजूर केवल आइए लिस्ट कर दिया जाए नेक्स्ट वीक।
ठीक है, कोई भी दिन आइए। अदर साइड से कंसेंट ले लिए,
कंसेंट
नोटिस दिए हुए हैं
जी।
क्या मैटर है? टाइटल सूट है।
हाँ, टाइटल अदरवाइज हुजूर मेंशन नहीं करते।
May I mention from the list number, serial number 17. The second appeal which your ladyship was pleased to admit on 12/8/2025 and direct that notices be served, thus the notices be served. That was done with supplementary has already been filed. In fact, my senior has already appeared. But I was just praying because that it may be taken up today because they are proceeding with the execution. The execution is listed on 15th.
Execution case has been stayed in your case, I remember.
It is not been stayed.
What is the substantial question of law?
Your ladyship, 3 substantial questions of law have been raised. Whether the judgment passed by the learned court is vitiated on account of the court travelling beyond the pleadings of the respective parties. Whether the judgment of title suit number such and such would be used to rely on evidence of the defendant in absence of certified copies of the depositions, and whether the statements recorded in the judgment can be treated to be an admission. And third, your ladyship, whether the learned court has erred in relying upon the unregistered compromise degree passed in FA number such and such and holding that there is no need for adjournment of tenancy. These are the 3 substantial.
You are the landlord or the tenant?
I am in possession of the.
He is the tenant.
Sorry?
He is the tenant.
Senior is appearing for the opposite side.
I am appearing lord for
आप
the
लोग खूब लड़ेंगे नहीं?
नहीं, ऐसा नहीं। हम लोग तो लैंडलॉर्ड हैं। इसको केवल इतना ही मेरा प्रेयर है, इसको डे आफ्टर फाइनल डिस्पोजल में।
आपको लग रहा है हमको इतना कैपेसिटी है?
नहीं, एकदम ये तो मैडम बिल्कुल डे आफ्टर फाइनल
Every week
डिस्पोजल।
the execution case is
नहीं, ठीक है, I am ready.
There is an idea for stay also.
डे आफ्टर
tomorrow.
डे आफ्टर
With the consent of the parties.
Lot.
Supplementary list for final disposal.
Final.
The records have come.
Yes, sir.
Yes.
You prepare your short notes also. लैंडलॉर्ड टेनेंट रिलेशनशिप के लिए सुप्रीम कोर्ट का डायरेक्शन है कि उसको एक्सपीडिशियस डिस्पोजल की कैटेगरी में रखना है। लैंडलॉर्ड टेनेंट रिलेशनशिप स्पेसिफिक परफॉर्मेंस ऑफ कॉन्ट्रैक्ट, दीज आर द 2 कैटेगरीज जिसको थोड़ा प्रायोरिटी हम लोग को देना है।
डे आफ्टर टुमारो।
Obliged.
Serial number 16, file 1, IA is there, it is coming under the 18 waters. So I file the injunction petition, I know that it will not be proceeded. But any date it may have, it would very short matter, otherwise actually very
Is
short.
it second appeal? First appeal? What is it?
First appeal, लेकिन it is actually
फर्स्ट
short.
अपील नहीं कर पाएंगे। आप देख रहे फर्स्ट
So
अपील में
only
एक बात
when
बताइए
taken up-
मिस्टर गुप्ता, इवन इफ इन फर्स्ट अपील you argue very short point of law or points on facts, लेकिन लिखना पूरा पड़ता है ना।
हाँ, लेकिन
You see, I am supposed to write everything.
बहुत छोटा फैक्ट है, नहीं तो हम ये नहीं करते। हम बोल रहे हैं सिर्फ एक बार मेरा आइए जो इंजंक्शन होना है उसको 4 बजे टेकअप कर लिया जाए, देन व्हाटएवर योर लॉर्डशिप, इट इज ऑलरेडी देयर इन द लिस्ट, इट इज देयर इन द लिस्ट, अदरवाइज आई वुड नॉट।
क्या हो रहा है आपका उसमें? थोड़ा
वही
वेट प्लीज, थोड़ा सा अभी ना, थोड़ा सा वी आर एब्सोल्युटली, यू सी आई एम मोर कंसर्न विद माय CAVs, राइट? अनलेस आई टेक केयर ऑफ दोस CAVs, ऐसा सुन के क्या होगा? सो आई एम really tied up with my CAVs. They are very lengthy matters. It is taking time.
So if your lordship takes it up and fixes a date even after 1 month also, your lordship, at least there will be something for
Okay, we'll fix a date post vacation. उसके पहले कुछ नहीं हो सकता.
or
Don't expect
whatever.
anything
I
prior.
cannot say that a particular date must be fixed.
Post vacation
Whatever,
ही होगा. जो-
whatever is convenient, your lordship.
Who is for the other side?
Vishal Kumar, I have taken his consent. Otherwise, because it is a short.
Come
matter-
at 2:15. We'll take up that
Yes.
as first case, and
Yes.
then we'll just
Yes.
pass an order of fiction.
Serial 13 matters for the supplementary powers. There is a physical appearance of BLO.
It is a contempt matter.
No matter. First appeal.
First appeal. Oh, he was supposed to assist the court, right?
He was required to deposit the amount before.
Yes.
the-
Have you deposited the amount?
But I has filed
For
extension
what?
of extension of time.
Why? Why does he need extension of time? Where is the money?
Treasury, madam.
Where is the money?
In the treasury.
So why? What is the problem in depositing the amount in the court?
वो अभी फ्रीज है मैडम, फ्रीज नहीं, हम लोग का 2 साल का एक्सटेंशन लेना पड़ता है 31st ऑफ मार्च के बाद में. ये एक्सटेंशन हम लोग को मिला नहीं है मैडम. तो रिगार्डिंग दिस हम लोग लेटर लिखे हुए हैं मैडम.
आपने कितना टाइम मांगा है?
4 वीक का मैडम.
ठीक है. लेकिन जब तक आप जमा नहीं करेंगे तब तक ये केस हम डिसाइड नहीं करेंगे. You get that? You are bound to deposit that amount in the court. Court के orders नहीं मानते हैं. आज कौन सा तारीख है? 9 से 4 वीक का हो रहा है. Seventh of October, right? We'll post it on 7th of October. Are you there? आप हैं उसमें?
I am one of the respondents, and I am the beneficiary of that.
लाइए जरा. कौन सा है सीरियल नंबर?
Serial number 13.
आइए नंबर बताइए. You have to complete certain formalities. That is the reason you have given, or कुछ भी बोले. What is the reason you have assigned?
वो लेटर हम लोग दिया हो.
Recalling. What is this? What prayer have you made? Recalling, setting aside the order dated 25/4/2025. You have drafted this? Yes. What is this recalling? क्या petition आप फाइल किए हैं? Have you filed a petition for extension of time, or it is for recalling or setting aside the order?
Extension of.
Show me.
मैडम वो आया है.
ये क्या है? Recalling क्या चीज के लिए फाइल हुआ था?
वो हो गया है.
उसके बाद कौन सा आई है?
आइए
आइए मंगल 2:15 बजे आई. आइए is not on board.
Your Ladyship, serial 22 most humbly seeking permission of this court to file supplementary affidavit.
इसके लिए हम मेरे परमिशन की जरूरत नहीं है. आपको मास्टर से परमिशन. सप्लीमेंट्री एफिडेविट का ऑर्डर था आपको फाइल करने का.
Yes, substantial question of law.
ठीक है. फाइल दे दीजिए. ये ऑर्डर क्यों है इस पे?
Obliged.
ऐसे मांगना नहीं.
From supplementary list for to be mentioned case item 1, second appeal 55 of 2003.
क्या एरर हो गया इसमें? अच्छा अच्छा. देखिए ऐसे नंबर 55 of 2023. This matter has been listed at the instance of the office. It has been pointed out that in paragraph 4 there appears to be a typographical error. In as much as notice has been directed to be issued to respond number 1 within bracket Roman 1 to 11 within bracket Roman 6, although it ought to have been 1 within bracket Roman 1 to 1 within bracket Roman 6. Peruse the records. The order dated 1/9/2025 is modified to the extent that in paragraph 4 The respondent number 1 within bracket Roman 1 to 11 within bracket Roman 6 is to be read as respondent number 1 within bracket Roman 1 to 1 within bracket Roman 6. Office to carry out the necessary corrections in the order dated 1/9/2025. Post on the prefix date.
Case item 3, second appeal 202 of 2017.
May it please your lordship. Just to recapitulate, my lords, the court contention of the case is that whether there was landlord-tenant relationship, particularly in view of the Kirayanama Exhibit 1. Number paragraph 7 of the trial court judgment was placed. Case of the plaintiff is that on 19/9/1984, a Kirayanama was executed by Mahavir Rajak, father of the present defendant appellant, stating therein that I will pay 60 rupees rent. Now, if I am permitted to read that Kirayanama, Exhibit 1, madam, it is in the lower court records. May I read it? मैं श्री महावीर रजक पिता स्वर्गीय वासुदेव रजक निवासी सर्जन सच मरार रांची रोड स्थित मकान जो मिल घर के बगल में है, उसे श्रीमती प्रमिला देवी पति श्री राजेंद्र प्रसाद साहू से मुबलिक 60 रुपए के दर से प्रति माह किराए पर लिया हूँ। मैं वादा करता हूँ कि हर माह के अंतिम सप्ताह में निर्धारित रुपए की एक उपरोक्त की रकम उपरोक्त घर मालकिन को चुकता कर दिया करूँगा। साथ ही साथ यह भी करार करता हूँ कि जब भी मालकिन हमें घर खाली करने को कहे, मैं सहर्ष सहृदय से बिना हिचक किए खाली कर दूंगा। इसलिए यह इकरारनामा अपनी राजी खुशी से लिख दिया कि समय पर काम आवे। दिनांक 19/9/84। Now look, it has been signed by Mahavir Rajak and the Kativ is Prabhu Prasad Sahu and Gawah is Nageshwar Sahu. Or Gawah is
Raghu Prasad Sahu is who?
Madam.
Raghu Prasad Sahu is in what capacity?
These are all for the plaintiff. They are Prabhu Prasad Sahu, he has written this document. Then Gawai is Nageshwar Sahu, and Gawai is Khalil Khan, and Gawai is Landhari Ram. He is PW3. Others are not before the court. Now this Landhari Ram says that this document was written in my presence and the plaintiff Pramila Devi had called me to be there and she had signed over the document.
He has not said that.
As she has.
That is not his examination in chief. In cross examination, he has stated.
तो क्रॉस एग्जामिनेशन में क्या होगा? I will test the veracity of his statement, and the court will consider it that for that the cross examination is made, because it is not known whether he is saying the truth or otherwise. So in cross examination he has said कि उन्होंने साइन किया था इनका सिग्नेचर है नहीं. My humble submission is that under section 107 of the TP Act, if a document is not signed by both the parties, that is inadmissible. There are judgments that even registered document which is not signed by both the sides, unilaterally if the document has been signed, that will not be admissible.
Please cite one judgment.
G.
Please cite one judgment.
My. Oh, sorry. But this is a division bench judgment of the Honorable Patna High Court, reported in AIR 1975 Patna, page 58. Equivalent is also given 1974 SCC online Patna 37 and 75 PLJR, page 27. In this case, the judgment was rendered by Honorable S.K. Jha J, as the Lordship then was. Paragraph 4, my lord, the Lordship have taken consideration.
What is the substantial question of law in this case?
My lord.
What is the substantial question of law framed
My-
in this case?
My lord, my lord. For that I may have to read it, my lord. The defendant in the appellate.
सर इतना नहीं पढ़ सकते आप सीधे सब्सटैंशियल क्वेश्चन ऑफ लॉ पे आइए ना.
Here the Lordship considered whether a registered document signed by one side would be treated as a document admissible in evidence. The Lordship held that under section 107 TP Act, signature of both the sides are required. Otherwise, even if registered document, it will not be admissible in evidence.
Well is that fine?
Madam? Yes.
Are you governed by 106 of the TP Act? Is this case governed by 106 of the TP
It
Act?
applies. 106 is regarding issuance of notice. That is not in question. 107 is the provision. 106 is duration of certain leases in absence of written contract or local leases. It is not in absence of a contract or local law or uses of, to the contrary, a lease immovable property for agricultural manufacturing purposes shall be deemed to be a lease from year to year, terminable on the part of either lessor or lessee by 6 months' notice. So these were notice, madam.
So,
And lessee movable property for other purpose shall be deemed to be leased from month to month, terminable on the part of either lessor or lessee by 15-day notice.
so it has got no relevance?
No. So 107 is relevant, my lord. Lease. 107. Leases how may? A lease of immovable property from year to year or for a term exceeding 1 year or reserving a yearly rent can be made only by a registered instrument. Here, my lord, exhibit 1 says nothing about the period of lease. That means it is a perpetual.
It is a month-to-month tenancy, sir.
तो कितने दिन के लिए है?
कितने भी दिन के लिए है?
11 महीना के लिए नहीं है.
नहीं भी होना है. It
Then-
only says a month-to-month tenancy. That's it.
तो month to month तो rent पे करना है. It is not for 11 months.
Need not be there.
Month to month tenancy means rent is payable month to month. तो 10 साल का भी होगा तो month to
10
month.
साल क्या 100 साल तक भी अगर डिफॉल्टर नहीं होगा तो नहीं होगा.
My lord, the period of tenancy, not payment of rent. Period of tenancy is the crux. It should be up to 11 months tenancy. 11 महीना के लिए आपको किराएदार रखा जाता है, तब उसका रजिस्ट्रेशन जरूरत नहीं है. But the moment it says it exceeds 1 year, then it will be and it will have to be registered under the Registration Act. That is the purport of section 107 of the Transfer of Property Act.
ये जो जजमेंट आप साइड किए हैं इसमें कौन सा पैराग्राफ साइड कर?
हाँ जी. First, I would like to place para 11. Then I will pray to your lordship to refer to other paragraphs. Para 11 is, it needs little argument to persuade me to hold that even if it be held that in effect Exhibit 5 was a deed of lease, it would still be invalid and cannot confer title on the plaintiff, since it being a registered document. It was imperative for both the parties to have signed in order to create a valid lease. Under section 107 of the Transfer.
107 is not attractive in this case.
My lord, in any case, if a document is not signed by the landlord, तो कोई भी आकर के हम लिख देंगे कि ये हम किराए पर ले लिए हैं, वो एक्सेप्ट हुआ है नहीं हुआ है, the landlord has to sign over it. Otherwise, it cannot be admitted into evidence. It's very unsafe. Anybody will say, हम लिख दिया 60 रुपया देंगे. She was interested in 5,000 rupees. बोलेगा हम तो लिख दिया. Then my lord will
ये जो इसमें है, all other leases of immovable property may be made either by registered instrument
Yes.
or by oral agreement accompanied by delivery of possession.
ठीक है. तो दोनों में से कुछ नहीं हुआ. Oral है नहीं.
Delivery of possession तो है ही ना.
My lord, my case is that.
So therefore it is not necessary to create a tenancy that there has to be a document.
No,
Not
not necessary.
necessary.
Not necessary.
Yes.
But if there is a
Not
document.
necessary. If a person comes and says that I want to take the property for monthly rent, then there is no period to that. There will be no period to that.
My lord, then
And
it has
then-
to be
and then-
registered.
No.
अगर clear नहीं है.
Oral tenancy होता है कि नहीं होता है?
Oral tenancy होता है.
होता है.
वो 11 महीने.
उसमें कहाँ होता है कि 11 महीना के लिए oral tenancy हुआ?
My
There is no
lord,
such concept.
that it will not be admissible.
Maybe.
Why? No document can be filed. That is my contention. अगर oral है तो कोई कागज नहीं फाइल होगा. उनको कहना होगा कि हाँ ये हमसे मांगे हमने इनको दिया. My case on the contrary is that vendor of the plaintiff, the present landlord, he had given me permission to construct a jhopri over a vacant piece of land. Now here the case is that the defendant has vehemently and very clearly denied the relationship of landlord and tenant. He has said he got permission from the vendor of the plaintiff that I give you this vacant piece of land, टाण लिखा हुआ है, टाण, और उनके भी सैलरीड में टाण लिखा हुआ है, जहाँ पर ये जमीन, जहाँ पर ये कंस्ट्रक्शन हुआ है. So in that case, when there is a complete denial of relationship of landlord and tenant, and there is a clear averment in the written statement,
सर आप प्लीज रुकिए मैं.
जी.
You continue your argument.
Why?
ऐसे ब्रेक नहीं करना चाहिए. Just
Yeah, I thought my lord is writing something.
जितना भी, no, I continue to write.
My lord.
ब्रीफिंग चेंबर में यहाँ नहीं।
Para 4 of the said judgment below, the defense of the appellant was, I was the defendant, I am the appellant here, same situation in that case also. I come to the relevant lines, that is fifth line from the top. There was no lease as alleged, nor could the document alleged to be the lease to be treated as a lease at all. The appellant further denied the relationship of landlord and tenant and that he was in permissive possession over the land in suit. Here also my case is that I am in permissive possession over the land in suit, and with the permission of the landlord, I had constructed a khapra post house having 2 rooms and veranda. Then Miller, I come down to last 5 lines of the said paragraph, and I may be permitted to read. It was further held that Exhibit 5 being a registered patta and signed by Ghulam Rasul alone, there the vendor, who do not confer any valid title on the plaintiff, as it was in contravention of the provisions of Section 107 of the Transfer of Property Act. The trial court further held that although the title pleaded and set up by the defendant, appellant had not been proved, the defendant was in possession of the land in suit since 1936. Here also we have said कि 70 साल से possession में 2008 में हम suit file हुआ उस समय लिखा, or at least from 1948, but not as a tenant of the plaintiff. On these findings, the trial court dismissed the plaintiff's suit. Here the plaintiff's suit was allowed, decreed. Therefore, I filed an appeal. Then, paragraph 8, my lord, Mr. Ramakant Verma appealing for the appellant urged a number of points in support of this case, this appeal. The number 2 is, in any event, the plaintiff had not been able to prove his title since the document purported to be the deed of lease, Exhibit 5, was clearly invalid, as it was not signed by the plaintiff. Here is the exact situation that the Kirayanama is not signed by the plaintiff.
सर प्लीज आप ब्रेक मत दीजिए, आप एकदम कंटिन्यूअस बहस करिए, हम सब चीज नोट कर रहे हैं। ऐसे ब्रेक करने से हमारा थॉट प्रोसेस भी ब्रेक हो जाता है।
Para 11, I have placed for my lord's kind consideration. Para 13, my lord, the last lines, this section is only available as a defense to the lessee, but does not give any right to him to claim possession or claim any other right on the basis of invalid lease. Then, my lord, I may be permitted to read para 15. It was further held that this is not a suit for any declaration of title and for recovery of possession. So, in absence of relationship of landlord and tenant, a suit for defendant's eviction under the BBC Act would not lie. although the plaintiff's title to the suit holding is seriously disputed and validity of surrender and settlement, etc., it is with respect to not connected with this case. In this suit for eviction, the scope is very limited, and I have nothing more to do than considering the relationship of landlord and tenant between the parties in respect of suit house for maintaining a suit for eviction. This issue is accordingly decided against the plaintiff. Now here, the issue has been decided in favor of the plaintiff. And finally, their lordship allowed the appeal and set aside the judgment at para 11. For the foregoing reasons, I would hold that the respondent has not been able to prove his title at all, and he cannot recover possession on the strength of title pleaded by him, because that was a unilateral signature. Here, the Kiranama is a unilateral signature, having unilateral signature of the alleged tenant, where the landlord has not signed. In the result, therefore, this appeal is allowed. The judgment and decree of the lower appellate court are hereby set aside, and those of the trial court restored, because the trial court had dismissed the suit, and the plaintiff suit is dismissed with cause throughout. I may be permitted to rely on a judgment reported in 2023 SCC Online Supreme Court 1216, paragraph 15, my lord. In case of Raichand Jain versus Ms. Chandrakanta Khosla, 1991-1 SCC 42, dispute arose as to whether certain premises were let out for residential purpose or as to whether there was an oral agreement of letting out the premises to the tenant for running press. It was in that perspective that it was held in the said case that a lease deed through though unregistered could be considered for collateral purposes to show the purpose for which the premises was leased out. It was not the genuineness of the lease, it was just only for the purpose of the lease money, for considering for collateral purposes. It was in that perspective that it was held in the said case that a lease deed, though unregistered, could be considered for collateral purposes to show the purpose of which the premises was leased out. Thus, the leased out deed was referred to for the sole purpose to defeat the claim of subsistence of oral agreement. The ratio of this authority has been considered in the case of such and such, and we follow that ratio. In the case of such and such file, another coordinate bench of this court declined to accept admissibility of the unregistered lease agreement for determining the duration of the lease 9 years in that case, on the reasoning that terms of lease would not constitute collateral purpose. Here, the terms of lease is right? It cannot be into for collateral purpose. It was observed in this judgment that nature and character of possession could constitute collateral purpose, but that was not the point which was directly in this before this court. In our opinion, nature and character of possession contained in a flawed document being unregistered, it is emphasized under the inverted commas, being unregistered in terms of section 107 of the 1882 Act, and section 17 and 49 of the Registration Act can form collateral purpose when the nature and character of possession is not the main term of the lease and does not constitute the main dispute for adjudication by the court. Here, my lord, the nature and character of possession is in dispute, that whether there is a landlord-tenant relationship or not. In this case, the nature and character of possession constitutes the primary dispute, and hence the court is excluded by law from examining the unregistered deed for that purpose. So, my lord, in this judgment also, the lordship said that to examine the nature and character of this suit, of the document, it cannot be looked into if it is an unregistered document. Here, my lord, it is a unregistered document, particularly not signed by the.
Sir, please don't repeat your argument. हम आपका हर एक argument note कर लेंगे. Repeat की जरूरत नहीं है. I have noted these two judgments and your argument on this point.
Then my lord will find that in the sale deed also,
Which sale?
there is sale deed which is filed by the plaintiff.
सर इस तरह से आप substantial question of law में confine करिए. आप first appeal नहीं pass कर रहे हैं.
Substantial question of law ही है कि ये रेगुलर सिविल सूट में इनको रिलीफ मिलेगा कि इविक्शन सूट में रिलीफ मिलेगा, वही तो है. If I am permitted to read
No, please
from-
don't read it. We have read it yesterday.
हाँ,
ये
Proceeding is a-
राजेंद्र तिवारी वाला जजमेंट कहाँ है?
मतलब
राजेंद्र तिवारी वाला जजमेंट.
Yes, madam. It was given at the time of admission, madam. Huh? Paragraph, particularly, if I am permitted to read, my lord, and give a copy, because it was given at the time of admission. देखिए तो दो नंबर लिख करके हम लोग दिए थे. In those days, my lord, sometimes the court was through video conferencing, and sometimes it was by
सर
appeal.
फाइनल हियरिंग के लिए आए हैं. ये 4 पन्ना का जजमेंट आप लेके नहीं आए, which is referred to in the order by which
Citation.
the substantial question of law was framed.
Yes, yes, my lord.
तो उसका
This
एक कॉपी
is-
लाने का रिक्वायरमेंट नहीं था.
My lord, उस समय दिए थे. आप हमको 10 मिनट टाइम दीजिए, हम लोग ला देंगे. 2002-101 SCC पेज 90. राजेंद्र तिवारी वर्सेस वासुदेव प्रसाद.
पैरा नंबर खाली बता दीजिए.
Para number 2, 3, 4, 7 and 17.
Page number
90.
पैरा 2, 7
2, 3, 4, 7 and 17. If my lord permits me, I can give my copy just now, but it is marked.
I don't, just for you to see.
I will read from this paragraph, खाली no other.
इसका फ्रेश कॉपी। ठीक है सर। आप बैठ जाइए प्लीज, डोंट स्टैंड साइड बाय द साइड।
It is
क्या है,
his,
कान में बोलते जा रहे हैं तब से।
it is,
आपको बहस करना है, आप बहस करिए, देयर इज नो प्रॉब्लम। आप साथ साथ में कान में अपने सीनियर के बोलते जा रहे हैं, इसका क्या मतलब है?
I am looking to a document which was not seen by me earlier. It is for the first time. From there I can read it extempore.
Which document?
जो बुजुर्ग को दिए हैं।
दीजिए ना, दे दीजिए उनको। हमको तो पूरा जजमेंट पूरा ऑलमोस्ट याद ही है, अब चिंता मत करिए।
तब हम क्या थे पढ़ने?
नहीं पढ़िए।
The plaintiff averred
we need to read
that
it.
para 2, the plaintiffs averred that they purchased the suit premises under 3 registered deeds, sale deeds, such as from one Kedarnath Sinha. Immediately thereafter let them out to the defendant on monthly rent of ₹300. Here the case is 60 rupees. On 19/9/1984, the defendant did not pay the rent from the date of commencement of the tenancy. The plaintiff had 6 years, and so the plaintiff wanted to set up their children in business as they are unemployed, and therefore they require the supervision in good faith. The plaintiff, he stated that they have taken the supervision rent from the Kedarnath Sinha about 33 years back. He has been in possession as owner of the suit premises. Para 3, my lord, the trial court dismissed the suit for eviction. Then in title appeal, the court affirmed the judgment of the trial court. The plaintiff then agitated their claim before second appeal in 304 of 1990 before the High Court of Judicature at Patna. On 9/9/1997, the High Court allowed the appeal, taking the view that an equitable decree of eviction could be passed against the defendant on the basis of the title of the plaintiffs and remanded the case to the first appellate court on ground that it did not record any finding on the question of title of the parties. That judgment of the High Court is brought under challenge in this appeal by the defendant. Mr. P.S. Misradil and team counsel appearing on behalf of the defendant contended that provision of Order 727 of CPC would not be attracted to the suit as the court was exercising limited jurisdiction under the Act, that is BBC Act. Mr. Mishra argued that in suit for eviction under the Act, the question of title to the suit premises could not be decided and that he had to be done that had to be done by a civil court in its ordinary jurisdiction, that is by a regular civil suit. Therefore, the High Court urged in law in remanding the case to the first appellate court for deciding the question of title of the plaintiff and passing an equitable decree for eviction of the defendant. In this case also, therefore, while framing the substantial question of law, their lordship said that the plaintiff can file a separate suit, regular separate suit, for declaration of title and recovery of possession. Therefore, I may be permitted to read para 7. It is evident that while dealing with the suit of the plaintiff for eviction of the defendant from suit premises under clause C and D of subsection 1 of section 11 of the Act, courts, including the High Court, were exercising jurisdiction under the Act, which is special enactment. The sine qua non for granting the relief in the suit under the Act is that between the plaintiff and the defendant, the relations of landlord and tenant should exist. The scope of inquiry before the court was limited to the question as to whether the grounds for eviction of defendant have been made out under the Act. The question of title of the plaintiff to the suit premises is not relevant, having regard to the width of the definition of the terms landlord and tenant in clause F and H, respectively of section 2 of the Act. Then I may be permitted to place para 17. However, we make it clear that the judgment does not preclude the plaintiff from filing a suit for declaration of title and for recovery of possession of the suit premises against the defendant. If such a suit is filed within 3 months from today, we direct that the same shall be tried along with suit filed by the defendant, title suit number such and such, for respective performance of contract against the said Kedarnath Sinha and the plaintiff. Well, I am submitting it for my understanding.
नहीं, उसकी जरूरत नहीं है हमारे।
Okay.
We'll get it.
Madam. Para 7 I have placed yesterday also the specific case of the defendant, my lord. In para 7 into bracket small b is that defendant has denied title and possession of the plaintiff of the suit land and also relationship of landlord and tenant between parties and pleaded that one Sipputan Singh was owner of the land.
We have already recorded that
Yes.
the case is of permissive possession.
My lord. Then, my lord, para 9, existence of tenancy. This was also placed by me. Para 9, now I have to examine whether the plaintiff, number 1, had let out the suit premises to the father of the defendant in year 1984 at the monthly rent of ₹60 as alleged in the complaint, and as such there is a relationship of landlord and tenant between the parties. Plaintiff, in order to prove tenancy, have examined 4 witnesses, namely PW1 Dileshwar Sam, PW2 C Prasad, PW3 Laldhari Ram, and PW4 Hiralal Saur, defendant. All the above witnesses have deposed to the effect that plaintiff number 1 had let out the suit premises to Mahavir Rajak, father of the defendant, in 1984 at a rental of ₹60 under a kiraya nama. It was not an oral tenancy, it was a tenancy created by a kiraya nama. That is exhibit 1, my lord. And that has not been signed by the person who has let out the house to the defendant. PW1 PW3 Laldhari Rama said that in his evidence of 1984, said Kiranama was executed by father of the defendant and it was signed by him in his presence. And in cross-examination, he has said it was signed by the lady also, the plaintiff. The witness has further stated he has also put his signature thereon as a witness. PW2 and 3 and 4, 2, 3 and 4 have also deposed that Mahavir Rajak, after his death, his son, defendant, paid rent of the suit premises till the month of November 1999, and in token thereof, Haj Chitta was being issued by the plaintiff. Now, my lord, I pause for a moment, my lord. Not a single Haj Chitta was given, not a single proof of payment,
Just
nobody.
a moment. Hard chitta was given to you.
ठीक है, तो कोई
लैंडलॉर्ड के पास कहाँ से रहेगा?
7 गवाह हुआ है, एक भी नहीं बोला कि मेरे सामने में एक बार भी दिया गया है पैसा. एक आदमी नहीं बोला, इंक्लूडिंग the plaintiff himself. Plaintiff is also one of the plaintiff is also a witness, and the plaintiff number 1 has not deposed. Plaintiff number 2, only the 2 persons are plaintiffs. Hiralal Saur, he has also not said कि मेरे सामने में पेमेंट मिला मेरी माँ को, and this has not been considered. The plaintiff has filed original kiraya number 19,994. I think it is wrong writing. It should be 1984. Exhibit 1. Allegedly executed by Mahavir Rajak to prove the tenancy of the suit premises. It has been submitted on behalf of the defendant. The alleged Kiranama is forged fabricated document and has not been executed by Mahavir Rajak. When I have placed such a clear-cut defense, it was incumbent upon the court or it was incumbent upon the plaintiff to get the signature verified by a handwriting expert. It was not done. So anybody writing Mahavir Rajak becomes signature of my father.
Anything else you want to say?
मालूम
Anything else?
थोड़ा सा प्लेस करना है. My humble submission is that when the defendant has said it is not signed by my father, then the plaintiff, it is in my written statement, it is in my pleading, it is in my evidence. The plaintiff did not choose to get my signature examined by a handwriting expert.
The father had expired by this time.
उनका सिग्नेचर तो है ना,
कहाँ पर?
और भी कहीं कहीं होगा,
कहाँ?
ये तो मुझको नहीं मालूम.
पूरे रिकॉर्ड में कोई उनका signature
नहीं, हम
रिकॉर्ड में नहीं है.
here in this case we cannot. The plaintiff ought to have brought other accepted signature.
प्लेंटिफ आपके फादर का एडमिटेड सिग्नेचर लेके आए. You
वो
want to
बोलते
suggest this?
कोर्ट हमको बोलती तो हम ला के देते. कोर्ट अगर हमको बोलती तो I am not going to bring everything, every record to prove the case for or against a party. It was a blunder committed by the plaintiff. He did not get it examined. तो कोई महावीर प्रसाद लिखता, हम भी लिख देते हैं महावीर प्रसाद. It will not become signature. Any court of law cannot treat a statement of either side to be true. It has to stand test of law manual. It has further been argued that the Exhibit 1 is not a kiraya nama and it does not bear signature of the plaintiff. The said document is unilateral document and also does not contain description of the land. My lord will kindly find from the Exhibit 1, kindly compare this Exhibit 1. I will come to the decree, my lord, and I will pray your lordship to kindly see. Decree says Schedule A, all that piece and parcel of Khaprapo's house situated over plot number 986, Khata number 17, village Barar, PS and district Ramgarh, consisting of 2 rooms measuring 10 feet into 14 feet each, with an open veranda measuring 15 feet into 16 feet, buttoned and bounded as follows: north, house of Dasarath south, house of plaintiff on 986 plot number, east land of plaintiff in plot number 985, and west land of plaintiff plot number 986. Now we will kindly allow me to read Exhibit 1. Not a single word is written. At least plot number would have been written. That is also not written. It has come in the evidence of the defendants that Mahavir Rajak was an illiterate man. Maybe he was signing, he was not signing, is different, but he was an illiterate person. And please compare the signature in Exhibit 1, Mahavir Rajak, and compare the script of the Exhibit 1. It is written by someone else. They ought to, and it was prepared at the instance of the plaintiff. She had called this Lal Dhari Ram. who is PW3 कि मुझको उन्होंने बुलाया, तो जब इतना ही ज्यादा पर्टिकुलर होकर के इसको बनाया गया था, तो प्लॉट नंबर तो एटलीस्ट लिखते हैं, कुछ नहीं तो किसी भी लैंड का हो सकता है, किसी भी लैंड का हो सकता है. So you know, exhibit 1 is not Kiranama, it is, and it doesn't tell me schedule A. Then how the court would grant a decree for execution of a case which is described in schedule A, that is not in the exhibit 1. There is no other document to correlate it.
ये वाला जो judgment
Now,
बोला जो को हमने 2-3 केस में कंसीडर Yes, please.
Minor. So court has failed to consider that exhibit 1 did not contain the details which is given in schedule A. And therefore the court has no authority to consider, to grant a decree or in favor of the plaintiff for the land having description in schedule A. That should match with the document which is said to be a proof of tenancy, and that document could be examined by the court only when it contains the plot number, boundaries, area, other details like room, size of the room, etc., veranda. Nothing is there. So when the suit was filed, it was prepared meticulously. When the document was prepared, it was prepared just by the way. It is all table work, my lord. Mahavir Raja was not even in the picture. Para 10, if I am permitted to read, my lord. At page 38. Now I come to the case of defendant. During the course of argument, it has been submitted on behalf of the defendant that one Singh was owner of 16 decimal of land of plot over 986, and the father of the defendant, namely Mahavir Raja, had constructed a Kacha Kaprakos house over 2 decimal of land of plot number 986 with the permission of Singh Singh. According to the defendant, neither the defendant nor his father was inducted by the plaintiff in the suit premises as a tenant, and no relations of landlord and tenant exist between them. When this very clear-cut statement was made, then it was incumbent upon the plaintiff to counter this. She has not countered. There is no amendment of the plaintiff. No, defendants' witnesses have said DW1 Baijnath was at DW2. Shiv Prasad Sahu have claimed themselves to be descendants of the recorded tenant of plot number 986, namely the Ali Mahato. So the recorded tenant descendants have come for deposing before the court. I will read, if permitted. They have very categorically, very properly stated. Namely the Ali Mahato, whereas DW3 himself, defendant DW3 Bimal Rajak, the present appellant before your lordship, the defendant has stated in his evidence to effect that father, who was a washerman by profession, had constructed a hut over plot number 983 when Singh Singh had purchased 16 decimal of land towards east out of 32 decimal in plot number 986 in the year 1939. Said Singh Singh had given 2 decimal of land of plot number 986 adjacent to plot number 983 to the father, to his father, and as such 2 decimal of land of plot number 986 came in his possession of his father during the cross-examination, the witness has stated that said Sipujal Singh had orally given 2 decimal of land of plot number 986 to his father, and no document was prepared in respect thereof. The suit premises is situated over 2 decimal of land which belongs to defendant. DW1 and 2 have stated to this effect that Sipujal Singh had purchased 16 decimal of land towards east out of 32 decimal in plot number 986 through a registered deed, and had given 2 decimal of land out of purchased land to father of the defendant, Vimal Rajak, in lieu of washing the clothes. The father of the defendant had constructed a Kapadapos house about 70 years ago over said 2 decimal of land and started residing there. So, on a vacant piece of land which was given by Sri Pujan Singh, Kapadapos house was constructed by Mahavir Rajan. And in such situation, when the land is given to a person, the provision of BBC Act will not applicable. Then in page 39 below at the bottom, the defendant has filed certified copy of sale deed dated 21/3/39 executed by Galu Mahato and another in favor of Sri Pujan Singh and Satnarayan Mahato, exhibit 2B, through which 16 decimal of land out of 32 decimal of plot number 986 have been transferred. It appears to me that defendant has filed this sale deed, exhibit 2B, to show that said Sri Pujan Singh was owner of the said 16 decimal of land of plot 986. But save and except oral evidences, there is no other evidence on record to show that that said Sri Pujan Singh had given 2 decimal of land out of 16 decimal of his purchased land in plot number 986 to the father of the plaintiff about 70 years ago. And the court has failed to consider that there is no cross-examination. If it was wrong, the plaintiff would have got cross-examined.
Respondent आप बोलिए.
थोड़ा सा और
Respondent बोलना चाहिए.
PW3, Sri Prasad Sahu claims himself to be descendant of the recorded tenant of the plot number 986 has stated in the examination in chief that said 2 decimal of land, it is not house, said 2 decimal of land of plot number 986 was given by Sri Pujan Singh to the father of the defendant. But in cross-examination, he has given different statement and reports that his father Jagmohan Sahu had given the land to Mahavir Rajan. In any case, the land was given. Over which he had constructed Kapadapos house, and also that he is not in possession of the supervises as a tenant of the plaintiff. So, in these circumstances, when a land is given, permission is given to construct a Kapadapos and stay there, the relationship of landlord and tenant under the BBC is not attractive. A regular civil suit under section 9 and 26 of the CPC could have been filed. That is the substantial question of law. Their lordship has said that if they want, the plaintiff wants, he can institute a case, and this admission of the second appeal will not come in the way. They can proceed.
फिर इनका submissions record करिए. पंकज जी. Essay number 202 of 2017. This appeal has been filed against the judgment dated 17/2/2017 within bracket decree dated 21/2/2017 passed in eviction title appeal number 6 of 2017, passed by learned District Judge Roman to Ramgarh, affirming the judgment dated 13/5/2014 within bracket decree dated 21/5/2014 bracket close in eviction suit number 14 of 2008, passed by learned civil judge within bracket Junior Division Hazaribagh. The suit seeking eviction of the defendant was decreed and the learned first appellate court has affirmed the judgment. Consequently, the defendant, the alleged tenant, is under appeal before this court. This appeal was admitted for final hearing by order dated 29/7/2021. By referring to the judgment passed by the Honorable Supreme Court in the case of Rajin Tiwari versus Vasudev Prasad and another reported in bracket 2002 bracket close 1 SSC 90. The following substantial question of law were framed for consideration. The learned counsel for the appellant, by assailing the judgments, has submitted that the core issue involved in this case is as to whether there was landlord-tenant relationship in view of the Kirayanama, which was exhibited as Exhibit 1. He submits that the alleged Kirayanama is dated 19/9/1984, said to have been unilaterally executed by the father of the defendant, that he would pay ₹60 per month for the he will pay ₹60 per month as rent. He submits that the Kirayanama neither contains the details of the property which is given in tenancy, nor it is signed by the plaintiff, and no period of tenancy has been mentioned therein, nor the Kirayanama has been duly registered. He submits that ex facie the Kirayanama could not be said to be an agreement of tenancy, and therefore no reliance could have been placed by the learned court on Exhibit 1. He has submitted that the Exhibit 1 was signed by Mahabir Rajak, the father, allegedly signed by Mahabir Rajak, the father of the defendant, but the defendant had disputed the signature of Mahabir Rajak over the Kirayanama. However, the plaintiff did not take any steps to get the signature duly verified from any handwriting expert. He has also submitted that as per the Kirayanama, there were 3 witnesses, and one of the 3 witnesses has been examined as PW3. And during cross-examination, PW3 has stated that Kirayanama was also signed by the plaintiff, but the Exhibit 1 does not contain the signature. He submits that this demolishes the veracity of the evidence of PW3. The learned counsel has submitted that the Kirayanama has not been duly proved. He has further submitted that he has further referred to Section 106 and 107 of the Transfer of Property Act, and has submitted that the Kirayanama was required to be signed by both the parties, and in absence of signature of the plaintiff, the unilateral act of the father of the defendant could not be taken into consideration, and this submission is without prejudice to the submission that the defendant had disputed the signature of the father of the plaintiff on the alleged Kirayanama. The learned counsel has relied upon the judgment passed by Honorable Supreme Court, Honorable Patna High Court, reported in 1974 SSC Online Patna 37, and has referred to paragraph 11 thereof to submit that in the said case there was a unilateral deed of lease which was Exhibit 5, and it was held that the same being the same was still invalid, it being a registered document. It was imperative for both the parties to have signed it in order to create a valid lease under Section 107 of the Transfer of Property Act. The Learned Counsel has then referred to the judgment passed by the Honorable Supreme Court, reported in 2023 SSC Online 1216, paragraph 15, and has submitted that the unregistered document can be used for collateral purpose, but when the very nature and character of possession is in dispute, the said Kirayanama could not have been taken into consideration, being an unregistered document. The Learned Counsel then referred to the judgment passed by the Honorable Supreme Court, reported in bracket 2002, bracket close 1, SSC 90, and has submitted that it has been held that the very existence of landlord-tenant relationship is the foundation for an eviction petition under the rent control statute, and when the relationship is not found to be established, any further inquiry into the title is beyond the scope of the court exercising jurisdiction under the statute. He has also submitted that under the Rent Control Act, the court exercises limited jurisdiction to try suit specified in the rent statute, and considering the facts of this case, the plaintiff is certainly free to institute a suit for declaration of his title and for recovery of possession. But in a case where the landlord-tenant relationship is seriously in dispute, the Rent Control Act itself was not applicable. That's all. Then, respondent.
Yes. Yes, please. Now, in this case, not my learned friend has referred, senior friend referred, both the judges. So, one thing, with a great respect to him, one thing I will make it clear. Now, your Lordship will find that first of all, there are 4 of the trial court judgment coupled with Para 22 of the appellate court judgment, where it has been found and held, which has not been placed before Lordship. As a matter of fact, earlier to this suit, a proceeding for fixation of fair rent was initiated at the instance of the plaintiff against the defendant. that was allowed by this rent controller sub-divisional officer, then, and it was challenged in appeal before the deputy commissioner. Deputy commissioner also allowed it. Fair rent was fixed, no payment. Then after filing the suit, there is a provision under section 15 of the Act, Building Act, the then Building Act 1982, where it is provided that during the pendency of the suit, the tenant of the defendant, so-called tenant, alleged tenant, because it was not decided at that time. So during the pendency of the suit, he is bound to oblige the provision of section 15. And if he fails to oblige, fails to pay rent, then the defense shall be struck. And that has been done in this case. This is recorded in para 4 of the trial court judgment and para 22 of the appellate court judgment. Now, defense co-tenant. The word is defense co-tenant. So, what my learned senior friend is arguing, first of all, this perhaps it has been missed from his mind. So, what I beg to place before Lordship is that the defense co-tenant having been struck off, now the defense which has been set up by the defendant, that it was settled to him a vacant piece of land for 2 decimal by the vendor of the plaintiff in 1934, and then he constructed a jhopadi. This is his case. So that is the defense. And having been struck off, still both the courts has not missed to take into consideration all the points which have been raised. So now this is one part. Second part, it is a canon of judgments settle the issue, that we are admittedly, and there is no dispute, that we are admittedly dealing with a case arising out of a Building Act. And what the judgment has been cited before your Lordship, Rajendra Tiwari's case, exactly the same, that in a case proceeded under the Building Act, foundation is Building Act, then the court is not required to see the right title interest. The power of the court is very limited. That is, whether the conditions, there are 3 conditions have been set up in the plaint itself. Number 1, default. Number 2, personal necessity. Only 2 conditions, personal necessity and default. And admittedly, when he sets up a case that I am not the tenant, therefore he did not pay any rent, so it comes within the clause of default. And secondly, with regard to personal necessity, the findings have been, concurrent findings have been recorded after considering the evidence on record and held by both the courts, that is para 12 of the appellate court and para 11 of the trial court judgment. With regard to personal necessity, now main issue is issue number 4. Issue number 4 relates to relationship of landlord and tenant. Much has been argued by my learned senior friend that there is no relationship of landlord and tenant. Referring to the document that is Exhibit 1. Now, Exhibit 1, the nature of the agreement, your Lordship may kindly see. My learned friend has rightly pointed out that the agreement I also accept that the so-called Exhibit 1 is not signed by the Pramila, who is the plaintiff number 1. Even I accept it. Then it is an acknowledgement, acknowledging his status and his possession over the land, suit property. That I am in possession of 2 rooms where I undertake to pay rupees 60 per month as rent to Pramila. This is an acknowledgement, and which he failed to serve. According to us, he has paid rent till November 1999, and thereafter he failed to pay the rent. Now, whatever it may be, it is a case of the defendant, it is an admission. And section 58 of the Evidence Act says that facts admitted need not be proved. Now, when he admitted that I have not paid any rent to the plaintiff, so it is a case of default. Now, one thing more. My learned senior friend also referred to section 106 and 107 of the
From where do you say that he paid the rent till November?
That is our case.
That is your case.
That is my case.
But there is no finding to that.
No finding, there is no finding. Finding is that he failed to pay rent.
That's right.
And there was an order. And reference, your lordship may kindly see the order passed by the subdivisional officer.
What is
That
that
is
exhibit?
exhibit. That is exhibit, my lord. I am just referring to the exhibit. My lord.
Exhibit.
Order passed by this, your lordship, just see for a moment the trial court judgment, the exhibit, reference of the exhibits are there. Exhibit 1 is the agreement. Your lordship will
नहीं
get, your-
एग्रीमेंट छोड़ दीजिए आप हमको वो एसडीओ का ऑर्डर देखिए
yes, ये वही हुजूर दिखा रहा है। Exhibit, एक मिनट, एक सेकंड। Your lordship may kindly see exhibit 3 series are the sale deeds, 4 series are the rent receipt. Yes. Your lordship would kindly see exhibit 2 and 2 by A. Exhibit 2 is किसका? पैरा किसका? ट्रायल कोर्ट का हुजूर पैरा 6A, पेज 43, 33 में।
जस्ट अ मोमेंट
2 by B.
जस्ट अ मोमेंट
Yes. उल्टा बोल रहे। 2 by B है।
वहाँ पे
SDO का।
दे बिफोर द सेड अथॉरिटी दे क्लेम दैट इट्स अ गिफ्ट they claim that it is a gift
Yes.
and here they say that they are in permissible.
Yes, that is there is a memo of appeal before the deputy.
The order itself, in the order itself it is mentioned.
Yes. So the order will not be on the basis of their memo of appeal preferred before the deputy comes. So 2 by A and 2 by B are the two orders, and those became final in absence of any challenge before the higher forum. So, in a proceeding under the Building Act, therefore the learned courts, both the courts, have placed reliance upon this. Lordship may kindly see for a moment. I will just take hardly a couple of minutes. Lordship may kindly see paragraph 11 of the trial court judgment. Para 11. In fact, para 9 B, C, D. I am not referring. Para 11. After discussion of the para 9 B, C, D. Subparagraph B, C, D, then your lordship may kindly come to para 11 of the trial court judgment. जो 9 स्टार्ट होता है पेज 36 से with regard to relationship.
That's right.
Para 36 trial court judgment.
हाँ.
Inner page
11 is conclusion.
हाँ, हम इसीलिए 9 A, B, C से डिस्कशन हुआ.
ठीक.
वो एग्जिबिट जो हम रेफर किए हुए एग्जिबिट 1 सी में है रेफरेंस, हम टाइम नहीं लेंगे उसका। रोमन डी में है, स्मॉल डी में एग्जिबिट 2A एंड 2B। ये जो रेंट कंट्रोलर के हैं जो तार डीसी के पास, उसके बाद अल्टीमेटली वो जो लॉसी में काइंडली सी स्मॉल जी में है जो 2 by B एग्जिबिट स्मॉल जी।
एफ तक है, जी तो है नहीं।
एफ के बाद जी है हमारा,
तो जी नहीं,
ई एफ ई जी है तो क्या 38 पेज में जो 38 ट्रायल कोर्ट जजमेंट का इनर पेज 10। हाँ यस जी है,
जी तो हाँ ऊपर है जी, वो पैरा 9 का जी,
पैरा 9 का ही जो जी का
ठीक।
तो मेरा डिस्कशन आई एम नॉट रीडिंग इट।
दैट्स राइट।
Yes. Then after discussion, ultimate finding or submission of both parties were recorded in the subsequent small paragraph. Then your lordship may kindly come to para 11. On the basis of oral and documentary evidences adduced on behalf of both the parties, I come to the conclusion that the father of the defendant, namely Mahavir Raja, was inducted as tenant in the suit premises on 19/9/1984. By the plaintiff number 1 at the monthly rental of ₹60, and upon demise of the father, the defendant continued in occupation of the premises as tenant. Therefore, I find and hold that relationship of landlord and tenant exists between the plaintiff and defendants in respect of the suit premises. The denial of title of the plaintiffs over the suit premises by the defendant is nothing but mere pressure upon his such and such. And there are 4 judgments which I will beg to place reliance, where it has been held repeatedly, what has been held in the Rajendra Tiwari's case. Then in a eviction suit arising out of a building act, the court has to limit itself within the 4 corners of building act. Nothing more.
Prima facie title.
Prima facie title. That can
Only prima facie. That
yes,
is not a
that is the law laid
conclusive
down
trial.
by the Honorable Supreme Court
Yes.
repeatedly. I am not
We have followed it in few judgments. वो
Yes,
लाइन का
it
judgment
recent
नहीं है।
judgment हुए जो था ये हमें कोऑर्डिनेट बेंच का भी जजमेंट हुआ जो आज से 3 महीना पहले का I am not encumbering not this settled principle proposition of law. Now your lordship may kindly see 107 and 106 which has been quoted in the judgment in 2023 SCC online.
That's
What my learned friend has relied upon. Your lordship may kindly see that is at page. There is no page number. Paragraph जो देखा जाए 9, para 9 of that judgment quoting 105 lease defined. Now, para 106 it speaks with regard to a lease of movable property for agriculture or manufacturing purposes shall be deemed to be lease from year to year. Our case does not fall within the category of that lease. Then your lordship may kindly come to 107. A lease of movable property from year to year. Our case does not fall within the category of that lease. Now we are in terms of the agreement for letting out a building under the Building Act. So, my lord, your lordship may kindly see any non-compliance of section 106 notice, etc. is not applicable.
no 107. It takes about year to year.
Yes.
Right.
Exceeding 1 year.
Only by a registered instrument.
But yes,
all
I
other
admit.
all other leases of inward property may be made either by a registered instrument or by oral agreement
Yes.
accompanied with
So
delivery.
therefore,
of
my case is not a case that it requires registration. It requires registration. This plea cannot be taken. Now, my lord, another aspect of the matter, if your lordship may kindly consider. What I have read from para 11 is the finding. Now, appellate court judgment, my lord, findings, it has been recorded in para 17. Para 17. Just see, after discussion right from para 14 onwards, taking into consideration para 14 at page 15, running page 15, in our page 9. This relates to the exhibit 1 starts argument and consideration. I am skipping those paragraphs. Para page number 18, running page 18, inner page 12. Towards middle, you will also just see the exhibit 2 by A and 2 by B has been considered by the appellate court. Then your lordship may kindly come to para 17. Para 16 first. The last 2 lines. The defense of the defendant on the point of eviction as tenant and was directed to be struck off with an order that the defendant will not cross-examine the plaintiff's respondent's witnesses on the point of eviction by the order dated such and such. That order became final. Then para 17. I have to determine the issues framed, whether there is any relationship of landlord and tenant between the plaintiffs and the defendants in respect of the suit premises. Then ultimately, not finding, the lordship may kindly see para 18 का जो बीच में exhibit 1 का discussion है. Exhibit सब सारा document, exhibit 2 by B, and ultimately para finding part you also will get, you know, 21. Then also 21. Sorry, 21 का concluding part, page 23. running page 23, inner page 17. गिफ्ट का बारे में भी वो देख रहे थे वहाँ जो लोग ले लिए थे. In this view of the matter, it can safely be held that the stand taken by the defendant appellant as to the owner of the supremacy is contradictory, due to which the contention of the learned counsel appearing on behalf of the appellant defendant regarding acquiring of ownership of the supremacy is not believable, and as such the same is not acceptable. So, in view of the discussion such and such circumstances, there is a relationship of landlord and tenant between the plaintiff and respondents and the appellant defendant in respect of the supremacy. So the concurrent findings of fact, it cannot be said each and every document, either oral or evidence, either oral or documentary, has been taken into consideration by both the courts, and this finding has been recorded, and this is finding of fact, concurrent finding of fact. In the second appeal. Now, Lord, your Lordship may kindly come to default, which I have already submitted there. Admittedly, they say that they have not paid.
Yes.
And even another aspect of the matter which was required in the Building Act, that whether partial eviction can satisfy the personal necessity of the plaintiff.
We need not.
That has also been decided.
That is not the question of
Not the question. I am not addressing this point. Now, your Lordship may kindly come to the question of law. I will not take much more time, Lord. Question of law, Lord. Your Lordship may kindly see whether in a summary proceeding where the relationship of landlord and tenant is not admitted, the defendant appellant can be evicted from a suit property. With great respect, under my humble submission that in a case governed by Building Act, even if the denial is there, relationship, but where there is no finding that there is a finding of the trial court that there is no relationship of landlord and tenant, then in such a case, no eviction can be ordered, directed. Here it is a case where the relationship of landlord and tenant has been established and concurred by the appellate court by finding of fact. Then in such case, this substantial question of law is not applicable in the present case. Next one, whether the plaintiffs have to file suit for right title interest and recovery of possession before the appropriate forum. That is also not correct, because even Rajendra Tiwari's case, when I sought relief for eviction other than Building Act, then I have to prove my title, then it should be a regular title suit. But it is not a case.
No, in a case where in a summary proceeding, there is a judgment in 2000, right? I'll give you the citation also.
Yes.
That citation is 2000 volume 8 SCC 123, which says that the court in eviction suit or Building Act also can incidentally go into the title.
Yes, I have seen.
And then the parties can have a regular suit, right? When the court talks about a regular suit, it can be a regular suit by either parties.
Either parties.
Right? They can
it is
also
not restricted to me.
Not restricted to you.
Yes.
They can also file a suit.
So
Therefore, under such circumstances, the first substantial question of law, at best, you can say that incidentally they were bound to go because that issue was raised, but that does not preclude even for them to seek a proper declaration with respect to their right title and interest, and that is open to both the parties.
Both the parties. No, but here in the
But there is no closure that that this issue cannot be decided at all, even incidentally in a landlord-tenant relationship.
Yes. Unless prima facie title
You
is.
see, the case of Rajendra Tiwari was under Order 14 Rule 11.
Yes, that is.
That the suit has to be dismissed at the threshold. Plaint is not maintained.
Yes.
The suit itself
That is
is not rejection of plaint.
And even the one judgment which has been cited by my senior friend, that is Patna High Court judgment 1974 SCC online.
Yes.
Lordship may kindly see very first paragraph.
Yes.
The suit for declaration of his title and recovery of possession It is not a suit under the Building Act. And in this context, it was considered, the document was considered.
No, it was the suit under section 11 of the BBC.
The ऊपर में मुझे लिखा है, respondent instituted the present suit for declaration of
1974 Patna,
1974 SCC online Patna
37.
jail.
The defendant is the appellant.
1975 defendant is Gajraj Singh,
Yes,
Ganraj Singh. उसका पैरा 1 पढ़ रहा हूँ. The defendant is the appellant.
yes.
Before this court against a judgment of reversal. The trial court had dismissed the respondent's suit, which has been decreed in appeal by the lower appellate court.
That was a
This respondent instituted the present suit
title suit.
for title suit for declaration of his title and recovery of possession with regard to survey plot number such and such, such and such.
Earlier, one BBC Act proceeding was initiated.
That is,
In
but
this case.
In this case,
Yes,
earlier.
earlier one BBC
Yes,
proceeding
maybe,
was
but
initiated.
this judgment is only with regard to the title
Title
suit.
suit.
So, my lord, the judgment does not help in the present facts of the present case.
That's all.
And then, my lord, the other judgments, my lord, which I beg to place reliance, that whether a tenant can set up a title himself, and that can be a subject matter of a suit. That is, after considering several judgments of this honorable court has been pleased to held in a series of writ petitions. Of course, it is arising out of SDO, then my lord deputy commissioner, then my lord commissioner, and ultimately before this honorable court, I was appearing on behalf of the landlord. And it has been held by this honorable court in a judgment, that is detailed judgment, recently, 20/12/24 का है. Go to there. इसमें सुप्रीम कोर्ट का जजमेंट रेफर्ड, उसमें पावर ऑफ अटॉर्नी में केस हुआ था, उसका भी प्लीड है, और उसमें 3-4 जजमेंट को कोर्ट के सुप्रीम कोर्ट, दैट कैन नॉट बी.
कौन सा पैरा आप रिलाई कर रहे हैं?
Yes, Lordship, just see, it has been quoted before the Honorable Supreme Court, ultimately. No, there is excellent, sorry. No. Para 19, first para 19, then we look, Lordship, may kindly see para 24. No, sir, 24 relates to power of attorney. I do not want to place reliance. Lordship, may kindly see, regarding the nature of the documents should be registered or not, para 31. And ultimately, my lord, the writ petition was allowed. Now, my lord, another 2 decisions, my lord, I beg to place reliance. One is, my lord, (2016) Volume 3, SCC 343. Paragraph 22 and 23. And then 2001 to the yes, 2006 Volume 3, JLJR, page 69, a judgment of this honorable court, where it has been held that the tenants are stopped from challenging the title of the landlord. The trial court not deciding any complicated issue of title, but incidentally discussing and holding the plaintiff as a owner entitled to file suit as no other. This is on this honorable court.
What is the consequence of defense being struck off?
Now the consequence, the co-tenant.
Title can certainly
Yes, title. But if it is a title suit, then in a suit instituted under the Building Act, then the suit with regard to co-tenant is struck off. He cannot open his mouth. Still, the learned courts, both the courts, consider everything. And another submission which has been advanced by my learned senior friend with great respect to him, he says that I should have taken effort to get this signature examined. When he is denying this document, I have placed it before the court. Now denial is on his part. So onus lies whom? The denial, the party who denies. So he could have taken an effort to get the document examined, and he never said that it was not signed by Mahavir Raja. It is a forged and fabricated document in his pleading also.
That was not their case.
Not said. But now submission before this on court, if here, even it at all subject to correction, even there is a averment that it is a forged document, he who pleads, he must prove it. So the onus lies upon him to get
take
it.
Steps.
Yeah, to take a step for examination. No such step. Rather acted upon, and it is not in this suit. It was also used in the proceeding under the Building Act. And that proceeding became final. No challenge after the appellate order. So having accepted both the orders passed by rent controller coupled with the order passed by the appellate authority, now he cannot take this plea in a suit that I am not a tenant. And as a tenant, he was directed to pay fair rent. Fair rent was decided, it was not ex parte. Rather, it was a contested proceeding. And on contest, he lost it. And he preferred appeal, statutory appeal. There also he lost. And therefore, both the courts had rightly placed reliance upon Exhibit 2 by A and Exhibit 2 by B. 2 by A, the order passed by the Deputy Commissioner in the appellate forum, and 2 by B is the original order. Having accepted that those two orders, now he cannot open his mouth. So stop it. These are my sums.
That's the learned counsel for the respondents, on the other hand, while opposing the prayer, has referred to paragraph 16 of the appellate court's judgment and has submitted that prior to institution of the suit, and has submitted that under section 15 of the Bihar Building within bracket Lease, Rent and Eviction bracket close Control Act, the learned court had directed the defendant to deposit the
Fair rent
decided by subdivisional officer
as a house rent controller.
As house rent controller. But the defendant did not abide by the order of the learned trial court, and ultimately his defense on the point of his eviction as tenant was directed to be struck off by an order dated 29/11/2010, observing that the defendant will not cross-examine the plaintiff respondent, will not cross-examine the plaintiff witnesses on the point of eviction. The learned counsel submits that the order of the rent controller was Exhibit 2 by A, and the appellate order dismissing the appeal was Exhibit 2 by B, and those orders had become final. The learned court has also taken into consideration the Exhibit 2 by A and 2 by B while deciding the case. The learned counsel has also submitted that there is no absolute bar on the part of the trial court under when a suit is filed under the special statute of rent control to enter into the issue of landlord-tenant relationship, to enter into the issue of title. In a I enter into the issue of prima facie title even in a summary proceeding, and the court has to see
in order to ascertain relationship.
In order to ascertain the relationship of landlord and tenant.
Yes.
The learned counsel submits that merely because the title has been decided,
The title has been discussed and considered,
has been discussed, and in order to arrive at the finding of landlord-tenant relationship, the same does not preclude either parties to get their title declared through a regular suit. The learned counsel has submitted that in the learned counsel has further submitted that the court has discussed all the materials on record to come to a finding. He has also submitted that in the proceeding before rent controller, the defendant had claimed that they were in possession of the property by virtue of a gift, and before the learned trial court,
by the vendor's vendor of the
by the vendor's vendor of the property
in 1942.
In 1942, and before the court in the present case, they claimed that they were in permissive possession since last 70 years.
Another thing not which I forget to remark. He came in possession on the basis of gift or permissive possession in 1942 onwards, and our sale deed is of the year 1954, and that sale deed was never challenged at any point of time.
But I will give a reply.
Yes, you will have your chance. Please hold on. The learned counsel has also submitted that the defendant claimed that they were in possession of the property since 1942. Since 1942, sir? Since 1942?
हाँ, इन लोग का क्लेम वही है कि 1942 में हमको परमिसिव पोजीशन मिला.
Since 1942, and the plaintiffs had purchased the suit property
by exhibit.
By registered
3 to 3 by C.
By 3
Exhibit 3
by
to 3 by
exhibit
C.
3 by A and 3 by C, which is dated 2/3/1956, 22/7/1957, and 22/1/1957. And at no point of time the sale deed of the plaintiff
By
Shri Pujan Singh was challenged by the defendant. The learned counsel has submitted that so far as the allegation that Exhibit 1, that is a Kirayanama, was not signed by the father of the defendant is concerned, it was for the defendant to take steps for getting the signature duly examined. He has submitted that since it was a case of the defendant that if the defendant disputed the signature, it was for them to bring on record the admitted signature and take steps for getting the same examined through a handwriting expert. But no such steps were taken from the side of the defendant. The learned counsel has submitted that the consequence of non-registration of Exhibit A, that is a Kirayanama, has also been considered by the court. And the court has relied upon all the materials on record to come to a finding of landlord-tenant relationship. The learned counsel has referred to the judgment passed by this court reported in 2006, bracket close 3 JLJR 69, to submit that it is open to the trial court to incidentally enter into the question of title with respect to the suit property. The learned counsel has submitted that the courts have given concurrent finding that the claim that the defendant have failed to place any material on record to show permissive possession over the property. He has submitted that both the courts have scrutinized the materials on record and have come to a definite finding that there was landlord-tenant relationship between the parties. He has submitted that merely because the landlord-tenant relationship between the parties is not admitted, the same cannot be a reason not to entertain a proceeding under the Building Control Act, and the court has to see the prima facie title to come to a conclusion as to whether there exists any landlord-tenant relationship. The learned counsel has submitted that accordingly first substantial question of law is fit to be answered against the appellant. With respect to second substantial question of law, he has submitted that the plaintiff he has submitted that the final adjudication of right, title and interest with respect to the property can certainly take place in regular suit, and such a suit can be filed either by the plaintiff or the defendant. And therefore,
सर इंटरप्ट नहीं, सर का ही किया हुआ एक केस है रांची बेंच में, यही प्ली लिए हैं जो हम लिए हैं, अब उसमें टेक अप मिस्टर जस्टिस गुरु शरण सर
फैक्ट्स अलग,
हम रात में खोज के निकाले,
आपको याद आ गया फैक्ट्स अलग था,
फैक्ट्स देख लीजिए,
फैक्ट अलग था,
नहीं होल्ड किए हैं, क्या सोच पढ़ा जाए, बिल्डिंग एक्ट के केस में टाइटल बोल ही नहीं सकते,
ठीक है तो है, तो वो फैक्ट्स अलग था। अभी तो हम बोल रहे हैं कि हम आपका टेनेंट नहीं, खाली जमीन
वहाँ पे वही बोले थे आप,
नहीं
आप मेरे ही जैसा
that's
बोले,
all. आपको क्या बोलना है?
But first of all, to wriggle out from the clutches of section 15 of the BBC, where the defense, my friend has said that it has to be struck off. My lord, we find from exhibit 2B, there is an order of the SDO, अनुमंडल पदाधिकारी रामगढ़ 7/12/2007, वर्तमान किराया निर्धारण बाद प्रथम पक्ष के द्वारा the plaintiffs of this case आवेदन के आधार पर प्रारंभ की गई। प्रथम पक्ष ने अपने आवेदन में ग्राम मरार के खाता नंबर 17 प्लॉट नंबर 985 रकबा 5 डिसमिल भूमि पर निर्मित कमरों का किराया रुपया 1600 रुपये प्रति माह की दर से निर्धारण करने का अनुरोध किया। इट इज इन रेस्पेक्ट ऑफ अनदर प्लॉट 985। द केस
सर किसी भी प्लॉट का हो, आपका डिफेंस तो स्ट्रक ऑफ हुआ था ना?
कैसे?
सेक्शन 15
डिफेंस
का
सेक्शन 15 का आपका डिफेंस स्ट्रक ऑफ हुआ था ना? आप एसडीओ का ऑर्डर भूल जाइए।
नहीं, उसके बेसिस पर ही कह रहे हैं कि आप 500 रुपए दीजिए।
किसी के भी बेसिस पर, that is not the subject matter of
I
consideration.
am not a tenant. I have stated here.
You may have stated, but the point is that in this particular suit, by a specific order, your defense was struck off. Correct or not correct?
in a suit.
In this particular suit, a specific order was passed, striking off your defense passed under section 15 of the BBC Act.
My lord, may kindly allow me to place.
सेक्शन 15 का अलग से ऑर्डर है इस सूट में।
My lord,
मे बी रॉन्ग ऑर्डर,
my lord,
वी डू नॉट नो।
it concerns plot number 985.
सर इस पर्टिकुलर, आप इस चीज को क्यों नहीं समझना चाह रहे हैं कि इस पर्टिकुलर केस में आपका डिफेंस स्ट्रक ऑफ हुआ है? इस पर्टिकुलर केस में आपका
That
डिफेंस
is
स्ट्रक
a
ऑफ
challenge even.
नो, दैट इज
और
नॉट
अगर
अ चैलेंज।
डिफेंस स्ट्रक ऑफ हुआ है, क्रॉस एग्जामिन तो हम कर सकते
हाँ,
हैं।
वो तो आप किए ही हैं जो आपको करना
हम
था।
कर सकते हैं।
ठीक है, बट
हम-
डिफेंस तो स्ट्रक ऑफ हुआ है ना।
हम
There
ये
was
तो
a
कह सकते
direction.
हैं ना कि इनका जो वो डॉक्यूमेंट ऑफ किरानामा है, that is forged. I have said.
ना वो ठीक,
प्लेट में हमने कहा है।
दैट्स राइट।
I will read from internal page 10
और व्हाट?
of the one minute. Of the trial court judgment manual. It is in the appellate court also. Internal page 9. It has this small e of paragraph 9. It has been submitted on behalf of the defendant that the plaintiff number 1 had filed the aforesaid case before the SDO for determination of fair rent of the house situated over plot number 985. Whereas the present suit has been filed by the plaintiff in respect of Kapla Post House standing over plot number 986. Since the SDO and Deputy Commissioner have passed,
सर आप समझना चाहते हैं कि नहीं चाहते?
हम मान गए।
बहुत क्लियर है इस पर्टिकुलर प्रोसीडिंग में।
हाँ, ठीक है।
देयर वाज अ डायरेक्शन टू मेक पेमेंट ऑफ रेंट,
मान
राइट, व्हिच यू डिफॉल्टेड
Yes.
and your defense was struck off.
Maybe. Yes.
Whatever be the background, we
Yes.
are not concerned.
My lord. Then my lord, what will happen? I will not be precluded from
That you
cross-examining.
have done.
And they have not pledged anything. Ki this is the signature verified by a handwriting expert. I have denied, and my friend has said.
No, you
That
have
under section-
cross-examined. That's right. That is another thing that you have cross-examined and whatever be the.
Section 101 of the Evidence Act, my lord. Burden of proof at page 47 of this small book of the professional book publishers. 101 burden of proof. Whoever desires any court to give judgment as to any legal right or liability dependent on the existence of fact which he asserts must prove that those facts exist. उसमें इन्होंने दिया ही नहीं कि ये महावीर रजा का सिग्नेचर है। If they had given, then burden of proof would have shifted on the defendant, myself. When a person is bound to prove the existence of the fact, it is said that the burden of proof lies on the person, on that person. तो जब ये प्रूव करते गए महावीर साहब का ही है, where because in the written statement I have said कि ये forged and fabricated document. I have filed additional also. additional written statement, I have stated that at 8 I have stated that similar to the that similarly the forged and fabricated Sada Kirayanaama 19 dated 19/9/1984, the judgment of partition suit number 57/93 is also false and fabricated on the basis of false persons, so it is not binding on the defendant. Then I again come to the case that regarding the house controller case also, I say that house controller case number 2 of 2006 is also not binding, as it was obtained by claiming fraud on the basis of separation of real fact and by unfair means. I am saying that I am not on 985. The case is also not on 985, it is on 986. The order of the controller was wrong. That there stands no relation, in para 11 I say that there stands no relationship of tenant and landlord between the plaintiff and the defendant with respect to any portion of plot number 985, 986 and alleged Sada deed dated 19/9/1984 is forged one, specially created and manufactured for the purpose of laying false claim, and as such it is not binding on the defendant, as because it is not admissible under law. So very particularly I have said if they were liable to prove it under 101 million of the Evidence Act. And in the in the evidence mirror, the present defendant, मैं विमल रजक पिता स्वर्गीय महावीर रजक शपथपूर्वक बयान करता हूँ।
सर इस आप उन्होंने जो बहस किया उसका जवाब दीजिए, आप फिर से बहस मत शुरू करें।
नहीं
जो भी आपको एविडेंस पेश करना है ऑलरेडी पेश कर।
पैरा 5 में हम स्पेसिफिकली लिखे हैं मेरे पिता महावीर रजक एकदम अनपढ़ थे और वे लिख पढ़ नहीं सकते थे, लेकिन उसी बेईमानी के वसीबूत हो गवाही ने उनके नाम से एक जाली चिट्ठा दिनांक 19/9/84 का बनाया, जिसे कथित तौर पर उनके दरखास्त थे। यह कागज किरायनामा की तरह जाली कर दस्तखत सिग्नेचर, यह कागज किरायनामा की तरह जाली तैयार करके न्यायालय में दाखिल किया गया है। मेरे पिता को ऐसे किसी भी जाली कागज की जानकारी नहीं थी। He says my father didn't know about this. अब बोलते हैं कि साइन हुआ। यह उनके मरने के बाद पहली बार सन 2006 में रेंट केस में दाखिल हुआ। My lord, it was executed in 1984. As per the plaint, it is alleged in 1990 बाद November 1999 का पेमेंट ही नहीं हुआ। What precluded him to even write a single letter after a month or 2 or 6 months? He was not paying rent and were stood defaulter. आराम से 99 से लेकर 2008 तक 9 साल बैठ गए। It is all manufactured. This is my humble submission. या कि किरदार नहीं थे और न ही उन्होंने कथित उसे कोई किराया दिया।
जो डेट स्लिप लिखा रहता है, जो उन्होंने डिफॉल्ट हुआ पैरा 4 ट्रायल कोर्ट जजमेंट में, डेट ऑफ स्टॉक ऑफ है 29/11/10 पैरा 4 ऑफ ट्रायल कोर्ट।
हां दैट इज इट जी।
29/11/10 है डिफॉल्ट। आपका 99 का पैसा नहीं है ब्लेड में।
डिफेंस
15 का जो ऑर्डर हुआ,
हां ठीक है,
29/11/10 एक। और दूसरी बात हुजूर ये जो कहते हैं 985 986 ये प्ली भी उन लोग लिए थे,
ये भी पूरा डिस्कस्ड है
पूरा ये जी में स्मॉल जी ट्रायल कोर्ट का जजमेंट जिसमें लिखा है कि ये एडमिटेड दैट इज 986
दैट्स इट
हैज बीन
986
यस। और अपीलेट कोर्ट पर
919 केस हुआ था एसडीओ क्या 985।
सर हम तो वही डिसाइड करेंगे ना जो सब्सटेंशियल क्वेश्चन ऑफ लॉ। I will आप लोग कुछ भी बहस करिए, हम I will confine it only to the substantial
जो इन्होंने बहस किया उसका सिर्फ जवाब।
हाँ ठीक।
Burden of proof was on him.
आप सर प्लीज रिपीट मत करिए, आपका कोई सबमिशन छूटेगा नहीं, आपके सामने लिखा है। The learned counsel for the appellant has referred to section 101 of the Evidence Act to submit that the burden of proof was upon the plaintiff to prove the Kirayanama Exhibit 1 and also the signature of the father of the appellant, and therefore it was for the plaintiff to take steps to get the signature to prove the signature of the father of the defendant. The learned counsel has also submitted that it has come in the evidence of the DW1, who was a defendant, that this Kirayanama was filed in the rent fixation case, and it came to light for the first time in 2006, and therefore the orders by the SDO with respect to payment of rent, with respect to payment of fair rent, was fraudulently obtained by the plaintiff. Yeah.
But
That's all. CAB post for judgment day after tomorrow.
day after tomorrow would be Thursday, my lord.
So,
Thursday. उस दिन पर्सनल हमको कुछ डिफिकल्टी
जजमेंट में आपको क्या जरूरत है? डिक्टेशन के लिए नहीं है, जजमेंट के लिए,
तो बस हो गया,
ठीक है
काम कर।
क्योंकि इसको सजाना पड़ेगा ना।
जी हाँ इन्होंने जो कहा था
सर अब हो गया,
अब ले लो माय फ्रेंड वाज इन हरी
ना ना
ही इज रिलीव्ड
हमारी में 7:30 से बैठे
जल्दी जाइए अब ले लो
ये मेरा दोनों जजमेंट रखूंगा। सर, ये जो ट्रायल कोर्ट और एपीलेट कोर्ट का फाइंडिंग्स है, उनसे पता ले लेंगे इसको। आप और फर्स्ट हाफ कौन डिक्टेशन दिया? पंकज, आप लोग को दोनों को मिलकर काम करना है। 4:30 बजे डिक्टेशन दिया।
इसको थर्सडे को सेकंड हाफ में रखा जाए जजमेंट।
जजमेंट से आपको क्या लेना देना? हाँ, वो
अगर
कंसर्न
आप लिखवाएंगे उस दिन
लिखवाएंगे नहीं, हम जजमेंट प्रोनाउंस करेंगे
अब तक
और शाम तक अपलोड भी कर देंगे।
वो तो हम लोग रोज देखते ही
From Supplementary List Item 2, Second Appeal 73 of 1997.
बताइए।
This is plaintiff second appeal lawsuit.
हम्म,
Plaintiff instituted title September 42 of 1988 lawsuit for declaration of right title and interest lawsuit, particularly to Schedule A land lawsuit. The suit was dismissed lawsuit.
क्या हुआ इसमें? रिस्पोंडेंट कौन है?
हम ही फाइल के पीछे रहते हैं। फाइल भी है। This is my senior is here. Yes, suit was dismissed also. Thereafter we confer appeal. Appeal also dismissed also. Kindly see substantial question of law framed by this honorable court. Order dated 5/5/98 also. Yes, may I permit to return? The first question from us. Further, any counsel for the appellant, this appeal has been filed against the appellant. Judgment and decree passed by the additional district judge Gumla in appeal number 31 by 92. The appellant's court by their first judgment and decree confirmed the judgment and decree of the trial court passed by the additional Mr. Gumla in title suit number 81 by 91, 42 by 88. The trial court had dismissed the suit of the present appellant against which the appeal was filed and different point of law and facts were taken, and after considering the arguments, the first appellate court also confirmed the judgment and decree. Against this judgment and decree of the first appellate court, the present appeal has been filed. It has been submitted on behalf of the appellant at the court. While deciding the appeal has committed error in holding that the CS entry will prevail over the RS Katyan, and therefore some substantial question of law arises in this appeal which are as under. First, whether in case of discrepancy between the entries
लॉ
in-
सेटल्ड है इस पर तो
Yes, law settled है lawsuit.
तो कहाँ है जजमेंट?
Yes, lawsuit. That will be decided. You will decide by the onward court lawsuit. Yes, paragraph 42. Let me see paragraph 42, page 26. 42, 43, 44.
ये तो सेक्शन 84 का है.
हाँ, section 84.
ये जो subsequent record of right would prevail over the previous one.
Yes, sir.
Yes, ये है 1963 AIR 1963.
हाँ,
Supreme Court 361.
इसको भी follow किया.
Para 49.
Para 49 है, yes sir.
This is directly in issue.
Yes sir.
हाँ, Para 49 this judgment लेके आइए भी 63 Supreme Court 361. This issue is settled, Mr. Sahni. You must be knowing. The subsequent entry will prevail.
Yes, yes. There is no doubt about the legal position, but
So just a moment.
yes,
So therefore, so far as the first substantial question of law
That I
is
will-
concerned,
I will demonstrate, my lord, whether this my lord, this point number 1 is available, my lord, on the facts of the case. Only I will take 5 minutes. But the law is very, that is well settled. Section presumption, my lord, under section 84(3) is there.
that's right.
And this, earlier it was cadastral survey, the now present one is revisional survey.
That's right.
So the revisional survey is later on. So subsequent change in the later on, the subsequent survey, that will prevail.
That's right.
And because there is a
On
presumption,
principles, there is no dispute.
there is no dispute.
But you say that on
in the facts
facts,
of the case, I will let my learned friend place the flag.
आप ही बताइए ना facts.
जी.
बताइए.
Now you see, मैं kindly see.
Yes, may I permit to place the fact of.
अच्छा,
जो उन्हीं को बोलने दीजिए, वो अपने तरीके से बोले.
Yes, first kindly see that plate of the title suit. बहुत छोटा सा plate और WS का बस ये दिखा देना.
लाइन से.
इसलिए second substantial question is also to be placed. I can understand the first one was sole question, then nothing to be added by from my side.
That's right.
Yes, para 1. The land in the khata number 39 with an area of 9 acres 78 decimal of village Jarda PS Dumri PS number 76 district Kumla were recorded in the name of Magru Ghosi and Soma Ghosi. This is admitted fact of it. Defendant also admitted this fact in para 6 of the written statement of it.
Okay.
So the land is 9 acres 78 decimal. This is the important of it.
I'll just note it down. Please hold on.
Total land is available of it. It is
Land is
total land is 9.78 acre lots
9.78
of khata number 39 lots
acre.
of village Jarda.
Khata number 39.
Khata number
Village.
Jarda, Dungri, Gumla. And in the
It's to recorded in the name of
name of Magnu Ghosi
Mag.
and Soma Ghosi. फैक्ट प्रोसेस
This is an admitted fact.
दिस एडमिटेड पैरा 6 में एडमिट किए WS में
Para 6 of the.
just WS रिटर्न स्टेटमेंट इसमें दो रिटर्न स्टेटमेंट फाइल होते हैं 1 2 3 डिपेंडेंट फाइल किए थे कंबाइंड फाइल किए थे और फिर रिस्पोंडेंट डिफरेंट नंबर 4 to 6 ex parte order was passed out and 7 to 8 filed separate written statement that is exhibit 4 lots who supported the case of plaintiff lots different number 4 to 6
They are the sellers of the plaintiff.
yes
Vendor.
they are the vendor lots of the plaintiff lots different number 7 to 8 and different number 9 is DC lots against whom also ex parte order was passed out no written statement filed lots.
Okay, 1, 2, 3 are the
Men contesting
Contesting.
different lots.
the plaintiff claim title through defendant number 7 to 8.
7 to 8
On the basis of registered sale.
on the basis of registered sale deed lots that is exhibit 1 lots on the basis of registered sale deed dated 6/1/87
6, 1,
6/1/1987
Exhibit 1.
exhibit 1 of area 1.66 hectare 1 acre 66
Yeah, 1.66
1.66
acres.
hectare lot. Thereafter land was also mutated lots. We filed an application lots for
Even in the second written statement filed by 7 to 8,
7 to 8 lots.
this fact was admitted.
Admitted.
They are the vendors.
They are the vendors of the plaintiff lots.
Okay.
They supported the case of plaintiff lots. Yes,
देखिए
sir.
एक सेकंड
No,
ऐसे
lots.
जस्ट
Yes, sir.
ये थोड़ा फाउंडेशन है ना
Yes, sir.
ऐसे नंबर 73 of 1997 within bracket R. The learned counsel for the appellant has submitted that the land that in para 1 of the plaint it was mentioned that land of 9.78 acres of khata number 39 village Jada was recorded in the name of Magnu Ghasi and Soma Ghasi, and this fact was admitted in the written statement filed by this defendant number 1 to 3 and defendant number 7 to 8. And the separate written statement filed and in the separate written statement filed by defendant number 7 to 8. So far as defendant number 4 to 6 are concerned, the proceeding was ex parte, and defendant number 9 was the deputy commissioner who never filed any written statement.
Yes. So ex parte order also.
And the proceeding was ex parte against defendant number 9 also. The learned counsel has further submitted that the plaintiff was claiming the property by virtue of registered sale deed dated 6/1/1987 within bracket exhibit 1 for an area of 1.66 acres in favor of the plaintiff.
Which is schedule A lot. Schedule A.
And
Schedule
the
A land.
property is mentioned in schedule
Schedule
A
A
land.
land. Yes, sir. Now, kindly, I am able to read paragraph 2 that the land in suit will be in schedule A and B of the plaint. That the recorded tenant Magnu Ghasi died without any male issue. He left 3 daughters. Genealogy first important है. Magnu Ghosi के 3 बेटे थे. नीरो घोषी, बीरो घोषी, थर्ड डॉक्टर के बारे में मेंशन नहीं है. वो डाइड इशूलेस आफ्टर मैरिज. 2 बेटी के बारे में मेंशन है, नीरो घोषी, बीरो घोषी. नीरो घोषी के 3 बेटा हुए. पत्रू घासी who is dependent number 1 lot. Patru Ghasi second son is Khasru Ghasi who is dependent number 2 lot. And third son is Lasru Ghasi. ये dependent number 3 है. नहीं
Patru-
Lasru Ghasi.
ये कौन हुआ? पत्रू is defendant number 1.
Patru Ghasi is dependent number 1.
हाँ.
Khasru Ghasi is dependent number 2. Lasru Ghasi is dependent number 3.
Yes.
Lasru Ghasi dependent number 3.
Defendant number 3.
मान.
और बीरो
बीरो घासी के 3 बेटे हो गए. रंगीला घासी डिपेंड नंबर 4. कोंडा घासी डिपेंडेंट नंबर 5,
Ponda.
कोंडा KONDA,
Dependent number 5.
5.
Okay. Third
फिर
one.
डिपेंडेंट नंबर 6 होगा फिरू घासी, PHIR,
PHIRU.
फिरू घासी,
Dependent number
डिपेंडेंट नंबर 6.
6. Okay.
यस सर. पैरा 3 जो हम बिलोंग कर रहे हैं, सो ये जो रिविजन सर्वे रिकॉर्ड ऑफ राइट में मगनू घासी और सोमा घासी के नाम से रिकॉर्ड लैंड था. मगनू घासी के 2 ये लीगल एयर्स हो गए. सोमा घासी हु इज डिपेंडेंट नंबर 7 एंड महगंग घासी. सोमा घासी के बेटे हो गए डिपेंडेंट नंबर 7 कास्तु घासी.
Dependent number 7.
कास्तु घासी
हाँ, और
MAH महरंग
and
घासी.
dependent number 8.
Dependent number 8 घासी. Who is quoted said it in favor of the plaintiff.
The learned counsel has submitted that Magnu Ghasi died, leaving behind his 3 daughters, Nero, Biro, and 1 more daughter whose name has not been mentioned, but she died issueless. Nero had 3 sons who were dependent number 1, 2, and 3,
Yes.
and Biro had 3 sons who were dependent number 4, 5, and 6.
Mine.
And so far as Soma Ghasi is concerned, he died leaving behind two sons who were dependent number 7 and 8.
Yes, mine. And dependent number 7 and 8 is quoted said it.
And dependent number 7 and 8 executed sale deed in favor of the plaintiff
For 1.66.
for 1.66.
Yes. That's it. That third part, that recorded parent.
अब क्या पढ़ रहे हैं, इतना क्यों
अच्छा
पढ़
इसमें
रहे हैं?
अब उसमें जैसे होती है, अब हम दिखा रहे हैं. इसके बाद में हम क्या होगा कि हम म्यूटेशन के लिए एक एप्लीकेशन फाइल किए.
आप मतलब कौन है आप?
आपने सबसे ये
You are the
Plaintiff.
हमने
You are the plaintiff.
हाँ, रैफल पिग्गा एंड हेलेना कल्को.
okay. You filed an application for mutation.
For mutation lord से.
Okay.
That is exhibit 6 lord. Mutation case number 47R
R
27/8788.
1987-88.
Dash 88.
That was allowed.
That was allowed only to the extent of 0.90 half decimal lord से.
0.90 and a half decimal.
By order dated 23/8/88. Passed by circle officer Dungri. 23/8/88.
88. Why? Why only portion was allowed?
हाँ, बाकी portion के लिए मेरा allow your kindly see annexure 6 lord से.
किसमें election is
No, sorry, exhibit 6 lord.
The learned counsel has submitted that the plaintiffs had filed an application for mutation, which was numbered as mutation case number 87 which was allowed partly only to the extent of 0.90 and a half decimal by the order dated 23/8/1988, which was exhibit 6.
Exhibit 6 lord. Yes, may I come to read out the exhibit 6 lord. They contested the notice was issued to the
mutation order was passed after due notice to
after due notice lord. And they contested also lord.
the contesting defendant.
Yes sir, contesting defendant. अभिलेख उपस्थित हुआ. इस आम इस्तेहार किया गया ग्राम जड़ा के पतरू घासी व लसरू घासी व.
ये आप क्यों ये सब पढ़ रहे हैं? मतलब I am not able to understand. You confine to the question of law.
बस वही दिखाना चाह रहे हैं. एक सर्किल ऑफिसर इसमें टाइटल एक तरह से डिसाइड कर दिए. उसमें जो
वो छोड़िए ना, सर्कल ऑफिसर ने क्या किया?
हाँ, वो 1.6 डिसमिल के लिए उनको म्यूटेशन करना था. सिर्फ 90 डिसमिल के लिए वो ये इसलिए किया कि हम यहाँ पर जो उनको ही फेल टू अंडरस्टैंड लॉर्ड सी एज पर टोटल लैंड है 9.78 एकड़. तो उसमें दोनों को हाफ ऑफ लैंड डिस्ट्रीब्यूट होता है. दोनों पार्टी में 4.89 एकड़ के लिए इंटाइटलमेंट था. तो आउट ऑफ 4.89 एकड़ लॉर्ड सी द Soma Ghasi son lord सी executed said deed lord in favor of the plaintiff for 1.66 acre land. सर्किल ऑफिसर यहाँ पर कंफ्यूज करके यहाँ पर बोल रहे हैं कि आधे हिस्से को दाखिल खारिज ही किया गया. 90 डिसमिल किया गया 1.66 के डेसिमल की जगह पे रॉन्गली इंटरप्रेटेड लॉर्डशिप
ये 190 किसका हाफ हो गया?
वही गलत फाइंडिंग इसी को दिखाना चाह रहे थे हम एग्जिबिट 6 में।
एग्जिबिट 6 के बेसिस पे आपका सब्सिक्वेंट सर्वे रिपोर्ट बना है क्या?
नहीं इस
ये रिपोर्ट तो पहले ही बना।
नहीं ये एडमिटेड फैक्ट है कि रिवीजन सर्वे रिकॉर्ड ऑफ राइट में दोनों का नाम है और 9.08 एकड़ जमीन है, ये दोनों एडमिटेड केस है। उसमें से 4.89 एकड़ जो दोनों पे डिस्ट्रीब्यूट हुआ है आपस में, उसमें से 1.66 मेरे फेवर में 87 में के वाला की है, एग्जिबिट हुआ है, एग्जिबिट 1 है, तो उसमें 1.66 को म्यूटेशन होना चाहिए था, 90 डिसिमल को गलती से किए है, उसमें बोल रहे हैं कि दोनों का गलत, उनका भी शेयर हमको मिल गया है। तो सर्किल ऑफिसर वाज नॉट इंटेंडेड लॉर्डशिप टू डिसाइड द टाइटल लॉर्डशिप कि हम उनका भी शेयर मिल गया, ये गलत उनका फाइंडिंग है, इसी के बेसिस पे हम टाइटल सूट फाइल किया।
तो
अगेंस्ट टाइटल सूट लॉर्डशिप, अब काइंडली सी लॉर्डशिप द जजमेंट पास बाय द लर्नेड ट्रायल कोर्ट लॉर्डशिप। इसमें एक चीज बस दिखाना चाह रहा हूं, डब्ल्यूएस ये रिटेन स्टेटमेंट ये लोग फाइल किए हैं, इनका बोलना है कि जो आरएस खाता नंबर 39 है, डिविजनल कैडेस्ट्रल सर्वे में उसका खाता नंबर 39 वो 37 था। हम दिखा देंगे रिटर्न स्टेटमेंट डब्ल्यूएस में कहीं भी एक
आप अपने आप को सब्सटैंशियल क्वेश्चन ऑफ लॉ में
हाँ उसी में बस दिखा रहे तो लर्नेड कोर्ट बिलो बस इसी इंप्रेशन में जाकर के रॉन्ग और पास और से कहीं पर प्लीडिंग नहीं है कि कैडेस्ट्रल सर्वे 37 इज कॉरेस्पॉन्डिंग टू द डिविजनल सर्वे रिकॉर्ड ऑफ राइट ऑफ सीएस 39 और से कहीं पर प्लीडिंग नहीं है, खुद का एक न्यू केस में डाउट कर दिए। और लास्ट में फर्स्ट अपडेट कोर्ट लॉर्डशिप आल्सो रिफ्यूज माय शेयरडीड वाज डिक्लेयर इलीगल लॉर्डशिप। मेरा शेयरडीड हम डिक्लेरेशन ऑफ राइट एट आया है, शेयरडीड माय शेयरडीड वाज डिक्लेयर लॉर्डशिप विदाउट एनी बेसिस लॉर्डशिप। दे हैव जो मेरे टाइटल वी परचेज द लैंड लॉर्डशिप अगेंस्ट द शेयरडीड लॉर्डशिप, दे नेवर preferred any suit lordship before any competent court of law lordship for cancellation of said lordship. Mutation order was passed in our favor lordship. Mutation order was also not challenged lordship. अब ये जो नया केस बना दे रहे हैं कि जो कैडेस्ट्रल सर्वे में मेरा नाम सिर्फ था, कैडेस्ट्रल सर्वे में बोल रहे हैं कि सिर्फ मगनू घासी का नाम था, मेरा नाम नहीं था, जबकि डिविजनल सर्वे ऑफ रिकॉर्ड ऑफ राइट में ये दोनों का नाम आ रहा है। माइनॉरिटी इट इज वेल सेटल्ड ऑर्डर डिविजनल सर्वे में प्रीफर लॉर्डशिप। हाँ ये इसमें जजमेंट हम दिखा दें इनका
अब क्या करना, तो डिविजन सर्वे आपके फेवर में ही है ना।
डिवीजन लेकिन देखा जाए फर्स्ट अपडेट कोर्ट लॉर्डशिप मेरा शेयरडीड को ही डिक्लेयर इलीगल कर दिया।
उसका बेसिस क्या है?
हाँ बेसिस हम सब दिखा देते हैं। ट्रायल
फैक्ट my learned friend is correct what has been said. In fact what happened, Magnu Ghasi is the only person of the family whose name was recorded in the year 1908. CS record of right was prepared in 1908, and in 1935, in between 30 to 35, arrest record of right was prepared. So in 1935 it was prepared, but the name of Soma Ghasi has been also included in the arrest record of right along with Magnu Ghasi. Now the plea which was taken by the contesting defendant that he has no relation with the family, and therefore the findings recorded they have been able to prove it, and therefore both the courts found that they plaintiff failed to bring on record any evidence showing what is the relation with Magnu Ghasi with Soma Ghasi. Merely lordship will, under the settled principle of law, entry in the revenue record of right cannot be a title.
You just tell
Their
us one
entry is
thing.
there.
You just tell us one thing.
What is the relation?
Even if the subsequent entry in record of right would prevail,
yes sir.
correct? It is only a presumption,
Yes.
and it's a rebuttable presumption under section 87,
Yes sir.
right?
Yes sir.
So therefore, the consequence of subsequent entry in record of right has to be seen,
Yes sir.
and that has to be seen with respect to the other findings of the court.
Yes.
Yes sir.
So
the finding is perverse in lordship because there is
no, merely no.
because there is no any
Let
pleading.
us take it that the subsequent entry in record of right will prevail,
Yes, sir.
right? But that is only a presumption. That is not a conclusive proof.
It is the duty, kindly see section 84 surplus 3 evidence of CNT Act. Every entry in record of right so published shall be evidence of the matter referred to in such entry and shall be presumed to be correct
Yes.
until it is proved by evidence to be incorrect.
Yes.
So it was the duty of the defendant lordship to prove it was incorrect.
Yes.
So because they have not bring any document lordship to prove it was incorrect lordship. They have produced lordship only their submission lordship, but they have not filed any in the averment lordship in the WS lordship that the CS record of right of 37 is corresponding to the RS record of 39. The court presumed himself lordship and gave the order lordship because there is no any finding such in the WS lordship. In the WS, there is no averment lordship.
Do you want to say that this particular record of right of CS and RS is
Yes,
not with respect to the same property?
No, the same property. Don't the same property, sir.
Then why are you talking about the subsequent khata number and the plot number and?
No, हम नहीं बोल रहे, ये बोल रहे हैं ना, इनका प्लेडिंग है कि 37 जो है वो 39 का CS रिकॉर्ड ऑफ राइट है. इसके लिए कोई डॉक्यूमेंट प्रोड्यूस नहीं किए जो.
तो ये जो CS रिकॉर्ड ऑफ राइट एग्जिबिट हुआ है 39 का एग्जिबिट हुआ है.
नहीं, CS रिकॉर्ड ऑफ राइट ये कहाँ एग्जिबिट करा हुआ है?
Because it has not been exhibited.
CS रिकॉर्ड ऑफ राइट का
एग्जिबिट D/1
नहीं, सॉरी.
कैसे कुछ भी बोलते हैं भाई?
नहीं, ये नहीं करवा पाए कि वो उसी का कॉरेस्पॉन्डिंग है. ये कोई डॉक्यूमेंट नहीं फाइल किया. एग्जिबिट CS 37 जो 39 का है, कोई डॉक्यूमेंट को प्रोड्यूस करना चाहिए कि उसी का रेसिप्रोकल है, उसी का कॉरेस्पॉन्डिंग है.
That is not the substantial question of law. If you dispute that it is not with respect to the same property,
Yes, sir.
तो इस substantial question of law का मतलब ही खत्म हो गया. Identity of property you will not be able to dispute considering the substantial question of law.
नहीं, CS रिकॉर्ड ऑफ राइट ये तो उनको प्रूव करना चाहिए था.
Identity of the property is in dispute
No, I'm
with respect to RS khata and CS khata.
Yes, sir. I'm
If
relying.
it is in dispute, that is not the substantial question of law.
I'm relying only the RS khata law. My name is entered. My vendor's name is entered in the RS record of right.
That's right.
और ये क्लेम कर रहे हैं कि सिर्फ एक्सक्लूसिव मेरा ही नाम था CS record of right.
Yes.
एक्सक्लूसिव जबकि जो सब्सिक्वेंट जो रिकॉर्ड ऑफ राइट है एविडेंस रिकॉर्ड ऑफ राइट उसमें दोनों का नाम है.
ठीक.
तो उसी से हम परचेज.
So there is a presumption in connection with the subsequent entry in record of right.
Yes, sir.
Right?
Yes,
And
sir.
they have to rebut the presumption.
Yes, sir.
It was for them to rebut the
Yes,
presumption.
yes.
So I just want to know, in the suit, was this entry in record of right under challenge?
No, we have also only claim lordship for declaration of right at an interest lordship for 1.66 acre lordship. Mutation जो मेरा जमीन का सिर्फ 90 decimal.
You were claiming on the basis of RS record of
RS record of
right.
right.
So therefore there was no reason for you to challenge it.
Yes.
Right? But did they ever take any step? Did they file any suit under section 87?
No.
Or did they file any suit
Yes.
for challenging this particular entry in record of right?
No.
Was this entry in record of right under challenge in the written statement? Was it under challenge?
No, not China because they are admitting lordship. This fact was admitting कि दोनों के नाम से evidence of record of right में इंटर किया हुआ था. इस fact में admit कर रहे हैं. Mutation भी हुआ वहाँ पर भी contest किए लेकिन उसके अगेंस्ट में वो challenge भी
Mr.
नहीं.
Sani, there is a presumption attached to it.
Yes, ma'am. But
Did you challenge it?
the entry in the arrest record of right has not been challenged by the defendants as a plaintiff. But when the plaintiffs brought this suit for declaration of their right title interest on the basis of registered sale deed executed by defendant number 7 and 8, sons of Soma Ghasi, then only this issue arose before the courts. Now the court very clearly, both the courts have very clearly found, because now the plaintiff has to prove its own case, that Soma Ghasi, being the recorded heir, along with Magnu Ghasi, has a right title interest,
That's right.
and therefore his sons have inherited that right title interest, and on the basis of such right title interest, they have executed the registered sale deed, and therefore the plaintiffs have the right title interest. That is the issue, Miller.
That's right.
Number, the issue is not, there was no issue whether the RS record of right can prevail over the CS record or CS record will prevail over the RS record. That was not the actual issue. If your lordship may kindly go through the, let my learned friend complete, I will show from the impugned judgments itself how the court proceeded. Now the court proceeded, the main question, when Mangu Ghasi and Soma Ghasi were alive at the point when the CS record of right was prepared. But they have to show the relationship between Mangu Ghasi and
No, whenever there is a entry in record of right, maybe in CS.
but the fact remains not. Mere entry in the revenue record of right does not confer any title, provided
Therefore,
it is
therefore,
there is a
therefore
presumption
there is a
of,
presumption.
presumption subject to rebuttal.
Did
Now,
you
your
rebut
lordship-
that
yes,
presumption?
subject to rebuttal, and there are so many evidence, oral as well as coupled with documentary evidence, have been discussed by both the courts, and those documents have been taken into consideration, and ultimately both the courts have found and held that Soma Ghasi has no relation with Magnu Ghasi. So mere entry of his name in the RS record of right did not confer any right title interest, so he had no right, his son has no right to transfer it in favor of the plaintiff. That is the finding. I will show from your lordship may kindly see for a moment. My learned friend has rightly read the case of the parties. Now, my lord, findings, if your lordship may kindly take first of all the trial court judgment. Trial court judgment, my lord. Issues are framed in para 3, inner page 3, para 3. Para 3. Second issue with regard to limitation, etc. Now the third issue, whether Soma Ghasi's name has been erroneously recorded during the RS operation in respect of suit land and Soma any title and possession over the same. Issue number 3.
Yes.
Then whether has the plaintiff got title and interest over the schedule A land, and has defendant number 7 to 8 got any title and interest over the suit land irrespect of the lands described in schedule B to the plaintiff. These are the main two issues. Now, your lordship may kindly see para 5. The next page, not page number 4. Issue number 3. This is very important issue which is required to be adjudicated upon. Nowhere in the plaintiff has tried to show any relation between two recorded tenants.
You are reading page number?
Page number 4, para 5 of the trial court judgment.
Page number 4. Page number 5 has
Para 5.
Para 4.
Para 5. Findings जहाँ लिखे हैं.
फाइंडिंग्स है लिखे वो पैरा 4
4 है, उसके बाद इशू नंबर 2 था.
हाँ, उसके बाद
नीचे,
ये
उसके
5 पढ़ा ही नहीं रहा है.
ओहो. इशू नंबर 3 होगा.
ठीक.
Issue number 3 very important issue.
That's right.
This is very important issue which is required to be adjudicated upon. Nowhere in the plaint or evidence the plaintiff has tried to show any relation between two recorded tenants, Mangru Ghasi and Soma Ghasi, in respect of RS Khata number 39. The plaintiff neither pleads Soma to have any relation with Mangru Ghasi, nor any genealogy or explanation is given to substantiate as to how the entry of Soma's name in RS record of right in respect of B having half share in the khata was made. The defendant, on the other hand, has tried to explain in his written statement that RS khata number 39 corresponds to CS khata number 37, which is in the exclusive name of Mangnu Ghasi.
This is purpose finding also.
No, अभी तो finding नहीं थी, discuss.
हाँ, discussion नहीं है. अच्छा, एक साथ है.
पढ़ देते तो
हमने इसमें बस कहीं पर भी नहीं लिखा.
आप ही पढ़ देते तो हम पढ़ते नहीं. And the contention, the defendant has filed the RS Khatian Exhibit D by 2 and CS Khatian Exhibit D and D by 1. आपको हर कोई डॉक्यूमेंट हमने दी. Exhibit D and DY1 shows that this CS Khata 37 is recorded in exclusively in the name of Maunu Bhasi. The defendant has also filed two village maps of Moja Jarda prepared on the basis of CS and RS operation, which has been marked as Exhibit E, Exhibit E by 2 and E respectively. On close comparison of the situation of the suit land in CS map, Exhibit E and RS map, Exhibit E by 1, coupled with the two survey khatyans as aforesaid marked as Exhibit D and D by 2, conclusively establishes the fact that suit plot of RS Khata number 39 has been carved out from the CS plot number corresponding CS Khata number 37. Exclusively recorded in the name of Mangu Ghasi. The defendant has also filed the rent receipts granted by the ex-landlord. ताकि RS खतियान बना हुआ 35 में तो ex-landlord थे उस समय. Ex-landlord filed marked Exhibit A series in which there are several rent receipts issued in the name of Mangu Ghasi in respect of suit Khata 39. Showing payment of rent exclusively by recorded tenant Mangu Ghasi. The defendant has also filed two state rent receipts in the name of Mangnu Ghasi, showing payment of rent for the whole of the suit land by the Mangnu Ghasi immediately after vesting the state granted in the year 1956 and 1958. Defendant number 7 and 8, who has filed their written statement, are sons of RS tenant Soma, who has not dared to participate in the trial, nor either of them has been examined on behalf of the plaintiff in the suit. There is no documentary or oral evidence to be produced there on their behalf to substantiate their claim and title possession over the suit land, either prior to the RS operation or subsequent to that. The defendant's case is that the recorded tenant Soma was working in the horse stable of the ex-landlord as a protector, which is supported by PW3 in his evidence. Para 2, who has unequivocally stated that the defendant number 7 has been living in a different village, namely Katimba, which is two coasts away from the suit village. The other witnesses of the plaintiff also admit that Soma, along with his sons, had left the village and has been living in another village. The recorded tenant Soma was never mutated in the Anchal office, nor any rent receipt was being filed on behalf of the plaintiff to substantiate the claim of possession of Soma or his sons, defendant number 7 and 8. Even the plaintiff's witnesses does not speak about Soma's possession or possession of his two sons, even after RS operation. Rather, there is pleading and evidence of plaintiff being in possession as Bataida of the two sons over the suit land, which is inconsistent with the such. There is no evidence or any material whatsoever to the effect of partition between the two recorded tenants. On the contrary, it is the contesting defendant who have filed the documents as aforesaid, including the rent receipts for the whole suit land, standing exclusively in the name of Magnu Ghasi. The defendant has examined DW 234 and 235 and also DW 6 of the suit village, who are all reliable and independent persons, who has spoken about the possession and title of the defendants over the suit land since the time of their father Mamnu Ghasi, and also that RS tenant Soma got his name entered in the revisional survey in collusion with the concerned staff. Hence, Soma never got possession over the suit land, and for the said fraud he had taken in the service of the Jamindar and also this village. Therefore, on the basis of documentary and oral evidence issued is caused above, it is found and held that Soma Ghasi, whose name was erroneously entered in the revisional record of right, and on account of such entry, for no title was conferred upon him. As such, I come to an irresistible conclusion that entry of Soma Ghasi's name in the revisional survey in respect of suit khata number such and खाता number such and such D/2 and exhibit 5 for the plaintiff is wrong and illegal, and Soma Ghasi of his sons, defendants number 7 and 8, had or has absolutely no title or possession in respect of suit khata number 39. Accordingly, this issue stands decided against the plaintiff. Issue number 4 and 5. The plaintiff has based the claim of his title and possession on a registered deed of sale executed by defendant number 7 and 8, sons of Soma Ghasi, dated 16/7/1987, Exhibit 1. Exhibit 2 is signature of PW2, Nicholas Pigga, made on the basis of sale deed as an identifier. This witness PW2 admits in his evidence in para 7 that he is the friend and relation of the two plaintiffs, hence a most unreliable man, instrumental in whole episode of the transfer of the suit land in favor of the plaintiff. This man seems to be the creator who has unnecessarily dragged the plaintiffs in the purchase.
You see, it is just a presumption, and that presumption has been completely rebutted. और आपका ये कहना that it is an admitted fact is also not correct, because paragraph 6 of the plaint has been explained.
Yes,
This para 1 of the plaint has been explained, and it says that the statement made in para is admitted so far as entry made in RS record of right. But Soma Ghasi had no concern with Mangu. पूरा explain किया है.
Yes.
ये कोई straight away admitted fact
Yes,
नहीं
yes.
है.
Kindly see the WS log.
हम देख लिए.
The WS में देख लीजिए.
देख लिए.
सब perversity हम दिखा देते
क्या
हैं.
perversity?
हम दिखा
कोई
देते हैं.
perversity का आपका substantial question of law नहीं बना.
नहीं, जो finding.
कोई भी perversity का substantial question of law नहीं बना. ठीक है? It is an admitted fact on record that there was an entry of Magnu Ghasi in the previous record of right. Subsequently, there was the entry of this both of them in subsequent RS record of right.
Yes, sir.
Right? And the court has considered the materials on record and has dealt with the presumption. And has come to a definite finding as to why this particular entry is incorrect.
The finding is wrong, Lordship. Kindly see, Lordship.
How is it wrong? Not, it's not wrong.
नहीं दिखा दे रहे हो. RS CS record of right के बारे में जो बोल रहे हैं उससे corresponding है.
देखिए,
No
आप
issue was framed, Lordship.
The moment you said that para 1 is admitted,
Yes,
and you did not say that what is written to reply of para 1.
Yes, kindly say W para 6, Lordship. W para W.
एक line admitted ऐसे admitted होता है.
नहीं, पर हम पढ़ के सुनाते हैं उसको.
Entry is admitted, हम तो बोल ही रहे हैं.
Entry तो admitted है, तभी तो सारा कहानी है.
That the statement made in para 1 of the plate is admitted as so far as the entry made in the RS record of right.
इसके बाद पढ़िए.
आगे नहीं पढ़े.
But Soma Ghasi has no concern with
Yes,
the Magnu
वो नहीं पढ़
Ghasi
रहे.
record. हम सब पढ़ कर सुनाते रहते हैं. कोई
तो
चीज़
पढ़ लिए
suppress नहीं
ना.
करते.
ठीक है, पढ़ लिए.
अब इसमें जो ये जो बोल रहे हैं कहीं पर हम WS में कहीं पर भी बता दें कि CS record of right जो है उससे corresponding है. कहीं पर
मैं
भी
प्रोड्यूस कर दिया हम लोग.
नहीं, मैं कैसे प्रूफ है? मेरे पास एग्जिबिट डॉक्यूमेंट है.
कोई बात नहीं.
D1 by D2.
अगर corresponding नहीं है तो पहला substantial question of law तो useless हो गया.
नहीं.
If it is not corresponding, then first substantial question of law is meaningless.
इनके हिसाब से उस जो बोल रहे हैं
You
कि
just tell us, you have got this first substantial question of law framed.
yes,
There is no dispute regarding identity of property. If there is any dispute regarding identity of property, the first substantial question of law will have no relevance.
इनका बोलना था उनकी डिस्क्रिपेंसी.
First appeal नहीं बहस कर रहे हैं, second
हाँ,
appeal
नहीं.
बहस कर रहे हैं. When you say that the subsequent entry would prevail,
Yes, sir.
you cannot question the identity of the property.
Kindly come to the first appeal court judgment.
We are not bothered about it. We are only concerned with the question of law,
Yes, sir.
right? Once you say that the subsequent entry in record of right would prevail
Yes, sir.
as compared to the previous record of right,
Yes.
then there is no dispute with respect to identity of property.
And in the subsequent survey record of right, Lordship,
We don't
name of
bother.
Soma Ghasi
Second
entered.
substantial question of law में क्या बोलना है? बताइए.
एक person
What
first
is misconstruction of title deed number exhibit
एक
1 and 3?
फर्स्ट अपडेट कोर्ट का ऑर्डर थोड़ा सा दिखा दीजिए.
अभी तो 1:30 बज गया, कल देखेंगे. लेकिन आपका कोई केस बन नहीं रहा. वो तो आपको भी पता है.
नहीं, हमको पता है कि अच्छा केस है, जो अदरवाइज नहीं करते. हमको लग रहा है रॉन्ग फाइंडिंग है सब
नहीं,
डॉक्यूमेंट.
ऐसे रॉन्ग फाइंडिंग नहीं होता है. ठीक है, सब्सटेंशियल क्वेश्चन ऑफ लॉ के
नहीं,
विदिन
फर्स्ट-
सब्सटेंशियल क्वेश्चन ऑफ लॉ.
फर्स्ट अपडेट कोर्ट मेरे सेडेड को इलीगल डिक्लेयर कर देंगे. हाउ इट इज पॉसिबल? काइंडली देखा जाए इसमें फर्स्ट अपडेट कोर्ट के अंदर जो
वैसा क्वेश्चन ऑफ लॉ नहीं बना है.
जो पॉइंट ऑफ डिटरमिनेशन की जो है
वैसा क्वेश्चन ऑफ लॉ नहीं बना, इसीलिए ऐसा चीज मत बहस करिए जो क्वेश्चन ऑफ लॉ नहीं है। इट्स नॉट देयर, वी विल नॉट बॉदर अबाउट इट।
यस सर, जो पॉइंट ऑफ
The court has recorded that Soma Ghasi ka entry in RS record of right was illegal, and therefore and consequently the sale deed executed by him is also illegal.
इलीगल है तो उसको चैलेंज करते हैं, कहीं चैलेंज नहीं किए, कहीं पर भी तो रिबटल में
आपका राइट टाइटल नहीं है, यही तो बोला।
नहीं, मेरा राइट टाइटल नहीं है, मेरे सेल डीड को इलीगल डिक्लेयर कर दिया, फर्स्ट अपडेट कोर्ट का जजमेंट कर दिया। पॉइंट ऑफ डिटरमिनेशन में हम दिखला देंगे,
माँ का या उनका बेटा का
जो
राइट टाइटल
जो फर्स्ट अपडेट कोर्ट जो पॉइंट ऑफ डिटरमिनेशन बनाया पूरा जो इशू फ्रेम हुआ उसी को बिल्कुल कॉपी पेस्ट हो गया, और जो उसमें से बोल दे मेरे सेल डीड को डिक्लेयर इलीगल कर दिया, मेरे सेल डीड को हाउ द फर्स्ट अपडेट को डिक्लेयर इलीगल नॉट। ठीक, कल इसको
देखिए रिक्वेस्ट है सर, फास्ट है, एक दो केस के बाद हो रहा है, सो दैट देयर कैन नॉट बी एनी प्रॉब्लम।
आपको लग रहा है एक दो केस के बाद फिर 1:30 बज जाता है,
हाँ तो
फर्स्ट अपील सेकंड अपील में एक दो केस के बाद 1:30 बज जाता है।
12:30 बजे अगर संभव आई एम नॉट रनिंग मैंने एक
आपको कल छोड़ के परसों रख देते हैं,
ठीक
ठीक है, लेकिन होगा 10:30
हाँ
बजे।
ठीक 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 है।
The hearing of this case has commenced. The court time is over. Post this case for further hearing day after tomorrow at 10:30 first case. बाकी कुछ दिखाए हैं उसको टाइप कर लेंगे, है ना?
इसमें अपरेंट में बंद कर देते हैं, सबमिशन केस हम लोग फाइल के हुए हो
कभी हुआ
कोई बात नहीं, वो तो पहले हो गया ना,
उसमें आगे
उसको अब जो करना है आप टीचर्स को
कर दिए।
ये मिस्टेकेड एसेस है, आज उनका केस है, क्या करना है? वेयर इज द अदर साइड? रिस्पोंडेंट्स आर देयर। The case is not being taken up for last 2 days.
Secondly, should the other side was here.
Where is he? The other side is ready. Are you ready with the matter?
What's it after 1 week?
Why?
Ready.
क्यों ready? 2 दिन से चल रहा है ये केस, 2 बार डेट हो गया।
After 1 next
क्या करना है आपको? रेडी क्या करना है आपको? बहस करना है किसी और को बहस करना है?
engage
कौन? हाँ?
Sandeep.
आप अपना जजमेंट का कॉपी इनको दे दीजिए।
It is annexure 1 in the.
It is annexure 1. आज नॉट टेकन अप में जाएगा तो नेक्स्ट वीक सप्लीमेंट्री में आ जाएगा। आई एम नॉट रिकॉर्डिंग एनीथिंग। अच्छा ऐसे लिखिए, काउंसिल फॉर द पार्टीज आर प्रेजेंट, द लर्नड काउंसिल फॉर द रिस्पोंडेंट्स prays that the matter be taken up on next Tuesday. Both these cases on next Tuesday in the supplementary cause list to be taken up at 10:30. 10:30 बजे आ जाएंगे, ठीक है? It is made clear that no further adjournment will be granted. That's it. उस दिन हो जाएगा।